The learned counsel for the parties. This petition has been filed for the following relief. The learned counsel for the petitioner has submitted that as per his class 10 certificate, the date of birth of the petitioner is 30/5/1994. And while he was minor, his father, who was in service of the respondents, expired on 1/4/2010. However, he attained his majority in the year 2012 and had applied for grant of compassionate appointment by filing an application through his mother and also himself. One such application has been annexed as Annexure 7 to the writ petition dated 3/1/2014. The learned counsel submits that as per the provision of the circular issued by the state government dated 1/12/2014, the application for seeking compassionate appointment can be filed within a period of 5 years from the date of death. The learned counsel submits that within the period of 5 years from the date of death of his father, he attained the age of majority and applied for compassionate appointment, but no decision has been taken by the respondent so far, and therefore the present writ petition has been filed. The learned counsel has submitted that the petitioner is highly qualified and has also the skill of typing. The learned counsel for the respondents has submitted that though no counter affidavit has been filed in the present case, but the fact that an application for compassionate appointment can be filed within a period of 5 years from the date of death of an employee is not in dispute. The circular referred to is circular contained in 10167 dated 1/12/2015. The learned counsel submits that the matter can be considered by the Compassionate Appointment Committee, which is headed by the Deputy Commissioner in terms of the aforesaid circular, and this writ petition may be disposed of by passing appropriate order for consideration of the case of the petitioner in accordance with applicable circular and other guidelines of the state. After hearing the learned counsel for the parties and considering the aforesaid facts and circumstances of this case, that the petitioner, as per the writ records, was born on 30/5/1994. His father expired on 1/4/2010, and the petitioner attained the age of majority in 2012 and had filed an application for grant of compassionate appointment within 5 years from the date of death of his father. This court is of the considered view that the case of the petitioner is required to be considered by the respondent number 3, who shall place the matter before the Compassionate Appointment Committee, where appropriate decision can be taken considering the applicable circular guidelines, etc. No adverse order in connection with the claim of the petitioner has been placed on record. This writ petition is disposed of enabling the petitioner to approach the respondent number 3 by filing a detailed representation along with a copy of the writ record and a copy of this order within a period of 15 days, 15 days from today. Upon filing of such representation, the respondent number 3 shall ensure that the matter is placed before the Compassionate Appointment Committee for due consideration in accordance with law, taking into in the light of the applicable circulars governing the compassionate appointment as claimed by the petitioner. The Compassionate Appointment Committee shall pass a reasoned order in connection with the entitlement of the petitioner within a period of 1 month from the date of representation and communicate the same to the petitioner through speed post. If the petitioner is entitled for any relief arising out of the decision of the Compassionate Appointment Committee, the needful be done within a period of 1 month from the date of the reasoned order. This writ petition is accordingly disposed of.
Item 2, WPS 4655 of 2023.
बसंती करके के बाद डिसीजन डिवीजन पे एवरी सिंगल other than Basanti Calcutta is also on the same. Basanti Calcutta has been considered in that.
We have also passed the order, but that order has not yet been corrected and uploaded. We
For.
have also observed that there is a direction in the contempt case by the Honorable Supreme Court that no order will be passed by the High Court in connection with the
That has been taken into account.
We'll take care of.
That Basanti Calcutta's judgment has been taken into account. And going on the 16.4 clause mirrors.
क्या नंबर है उसका? सौरभ कौन सा क्या नंबर है उसका? WPS नंबर? The learned counsel for the parties are present. The learned counsel for the petitioner has fairly submitted.
No, it's not fair. It's on their part. I'm not
Okay.
fair.
This also on their part?
It's on their part.
Just a moment. Just a moment.
Because I have prayed from this.
No problem. This writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the matter relates to recruitment under advertisement number 21 of 2016.
Yes.
He submits that the same was subject matter of challenge before this court in the case of Soni Kumari and other analogous cases which ultimately travelled till the Honorable Supreme Court in Civil Appeal number 4038 of 2022 and 4044 of 2022 and other analogous cases. The petitioner was taking regular updates in connection with the selection process, but for almost 5 years, the petitioner could not remain updated, and the judgment was passed by the Honorable Supreme Court on 2/8/2022, and an intimation through website of the respondent was published, which the petitioner could not know, as there was no individual communication to the petitioner.
And only one in Milord's
opportunity was
No,
given.
3 opportunities are mentioned in the counter affidavit also.
Okay.
There
The
were three
learned counsel
opportunities.
submits that only one opportunity was granted.
In which 3 different dates were there. That is the fact.
One opportunity, 3
One
different days, that
notice.
amounts to 3 opportunities.
One notice with 3
One notice with 3
Three
dates.
opportunities.
3 dates.
The learned counsel for the respondents has proposed the prayer and has submitted that a number of orders have been passed by this court, including in WPS number 3436 of 2022, WPC number 1522 of 2019, WPS number 975 of 2019.
And 2 of your lordships already also.
Yes,
4933 of
and WPS number 4933
of 20.
4936 of
23.
20.
23.
23 with WPS number 5768 of 2023, and the matter is squarely covered. The learned counsel has also submitted that there was a clear direction of the Honorable Supreme Court that no contrary order from what has been not required, that should be sufficient.
This is not required. This
Yes.
is
Because the
covered by
advertisement
the.
itself contained the provision because that only, it is the fault on the part of the candidate because it is not able to fulfill the requirement.
The learned counsel submits that no relief be granted to the petitioner. She has also submitted that although there was one
Notice.
notification in the official gazette, but there were 3 opportunities given. These writ petitions are accordingly dismissed.
Dismissed.
All right. I will just pass the order.
Okay.
I have to incorporate all this. I will do it.
Because the relevant provisions of the Miller's advertisement is there in the counter affidavit also.
We'll take it.
That has been quoted in Hindi Miller's.
We'll take it.
Item 3, WPS 6467 of 2023.
Yes, petitioner.
जो पता चाहिए था आईएएस का पोस्ट नहीं है योजना विकास विभाग का
So who is for the respondent? Sorry.
Yesterday we have communicated to the department, Your Lordship, but there is not time for replying this communication. But if he has prepared the reply, Your Lordship, it may be
Disposed of?
Your Lordship,
No, he has already retired and he is seeking promotion. You want a disposal? Is he entitled for promotion post retirement?
no, Your Lordship.
Then? मुझे दीजिए तो झारखंड सर्विस को. Okay. The learned counsel for the petitioner on instruction submits that the petitioner never belonged to IAS cadre. The learned counsel submits that the petitioner attained the age of superannuation on 31/10/23 from the post of deputy director. You just take this order on 19/2/2024 following also was passed. The learned counsel for the respondents is directed to seek instructions and file a counter affidavit giving the details in connection with the holding of meeting of Departmental Promotion Committee after 24/12/2020, the vacancy position from time to time till the date of his superannuation, and whether the petitioner was within the zone of consideration for promotion. The counter affidavit should also indicate that. Should also indicate as to whether any person junior to the petitioner has been granted promotion as claimed by the petitioner. The counter affidavit should reflect as to whether the claim of the petitioner is just a financial upgradation, and if there is any impediment in granting financial benefit to the petitioner by giving notional promotion, taking into consideration Rule 58 of Jharkhand Service Code. The counter affidavit be filed by the respondent number 4. Personal Administrative Reforms Department would be the best authority, isn't it? By the respondent number 4. Date the counter affidavit be filed by 6th of March, rejoinder by 13th, post on 18th. Under the heading for admission. Next.
Item 4, WPS 6839 of 2023.
Yes.
Already you have gone
These
through
are
the-
your grounds, right?
Yes, madam. And there are two judgments passed by the coordinate benches to that effect also. One is dated 3/1/2024.
Where is that?
It's here with me. Where one of the case regularization, consider regularization has been ordered. And in another judgment of the coordinate
Where is
bench,
that? Go just a moment.
15/1/2024, another judgment.
Just a moment. This is one judgment saying what? So you are seeking regularization by virtue of this.
Regularization as well as such, my prayer is not regularization, my lady. My prayer is the
No,
quashing.
no, let us see. This is just an order for consideration of your representation.
There's another judgment of dated 15/1/2024 where order has been passed to constitute a committee.
No, that you are not entitled to regularization, therefore there is no question of constituting a committee.
My lady, this has been the contentions of the MG and REGA workers was also considered in this particular 15/1/2024, where there were writ petitions from the MG and REGA workers also to consider their regularization. And the relevant paragraphs of the Narendra
That's
Kumar.
right, it is just a consideration and formation of policy, right? It has got no relevance. Is there any direction for regularization?
Regularization does not exist, my lady, as a matter of right, which I accept and concede also.
No, it does not apply to Manrega at all. This is what we have held.
Manrega is.
You have seen that judgment?
Yes, ma'am.
Yes,
I've seen
My
that.
judgment you have seen?
Yes, ma'am.
I have categorically held for Manrega there is no question of regularization.
But my lady, may I insist this honorable court to go through the para 5, 7 and 8 of the Narendra Kumar Tiwari judgment, which says that the state cannot perpetuate on illegality forever. And it was a categorical instruction to the state of the Jharkhand that they must consider the regularization of such employees. And
Which employees?
the ad hoc employees or
No,
the.
it is not. You say it is contractual appointment. Your
Yes, this is-
appointment is contractual appointment
Yes,
for a fixed term under Manrega scheme, which only guarantees 100 days of employment.
No, my lady, I am working as a Gram Rojgar Sevak. I am not under that 100 days muster roll, my lady. There are various other employees who are appointed for the implementation of the program.
And it is just you were working as what, under what post?
Gram Rojgar Sevak and computer assistant, my lady. And I
No,
was
computer assistants are also here.
yes, my lady.
Who are computer assistants?
The
amongst
second
them?
petitioner is a computer assistant, my lady.
Okay.
I'm not
First one
sure.
is
The
First
first
one
one
is-
is Gram Rojgar Sevak. And the second one is a computer assistant. I beg your pardon, it is account assistant, not computer assistant. It is account assistant. So I'm not here for those
just a
daily.
moment. What is the advertised post? And you were working where? Dhanbad.
Yes, madam.
You have annexed this annexure 2 of Hazaribagh.
Yes.
Why? How is it relevant?
This is a Hazaribagh Pramandal. That under Hazaribagh Pramandal that
Dhanbad is also there.
yes, madam.
Dhanbad falls under Hazaribagh division.
That has been indicated, my lord.
Where is it
my lady.
indicated?
.43. My name is entered at
No, your name is another thing. But the point is that you belong to Dhanbad. You have taken employment in Hazaribagh. Now this particular
this
advertisement
falls under the Dhanbad, this Hazaribagh Pramandal. This order was pronounced by the Ayukt Karyalay Uttari Chota Nagpur Pramandal.
That's right.
Hazaribagh.
So you are working in Hazaribagh division. And the
Technically-
advertisement is of Dhanbad. How are you aggrieved?
This is also for the this is the same Pramandal.
No.
But
Hazaribagh.
the Pramandal over
Dhanbad.
period-
It is for Dhanbad.
there has been some administrative changes which
You
has
do not
occurred.
know. You see, your appointment as per your annexure is for Hazaribagh. And you have challenged the advertisement of Dhanbad. How are you aggrieved?
Your
Because
leadership may-
because I've been working in Dhanbad for the past 15 years, my lady.
From where do you say that you are working in Dhanbad when your appointment is in Hazaribagh division?
So I'll annex the latest document of that.
You do not know. You see, this is so much of mismatch. And you see, this Lekha Sahayak, come to the advertisement.
Yes.
You are concerned only with Gram Rojgar Sevak,
And the Lekha Sahayak.
Lekha Sahayak also, right?
Yes.
Gram Rojgar Sahayak is not even advertised. Is it advertised?
No, my lady, that has not been advertised.
So how are you aggrieved?
My lady, because this will create a rival pool of the
Please.
contenders,
No,
the
we
ad
do
hoc
not
employees.
You see, you are working as Gram Rojgar Sevak.
Yes, ma'am.
There is no advertisement for Gram Rojgar Sevak.
Yes, ma'am.
Then how are you aggrieved by that advertisement?
So let it be considered as my second petition. I'll press the.
So far as the second petitioner is concerned, there is only vacancy of 6 persons.
Yes, ma'am.
So
My lady,
they are only filling up the vacancies. They are
this-
not dislodging you.
They are not dislodging me, but at the same time, it has been accepted by them in their own resolution that was passed on 28/5/2013 that under the orders of the Honorable Governor that it is difficult to meet the salary expenditure which I have recorded in my
You see
paragraph.
that you cannot challenge the advertisement unless you are being displaced or somebody. There's just a vacancy of 6 persons.
This has been recorded in the judgment of the coordinate bench also 15/1/2024 that
I
it is
just you just
creating
tell
a
us
kind of.
for 6 vacancies, they are just advertising only for the vacant position. They are not disturbing you.
My lady, it will create a position where they will.
In anticipation, you cannot file a writ petition.
No, my lady, there is already a burden on the state exchequer as to be bearing the salary expenditure. My salary.
You don't bother about the burden of the state exchequer. They will take care of their finances,
Certainly,
right?
my lady. So let them
So,
explain. Let them
then
explain
no,
that
no,
how they
no.
are going to
No,
bear the
no,
salary
no.
expenditure.
No.
In the past 15 years, my salary
The
when
question
I joined.
and the selection process is over, perhaps.
No, the selection process is not over.
From where do you say?
The recruitment process is not complete. The
From where do you
appointment.
say?
As
Because
per
as per the schedule of selection process, the time period is over.
the time period may have elapsed, but they have not appointed the said person to the said post.
Where do you say this?
On the basis of the instructions from my client that this is what is the latest update.
I am not satisfied prima facie. There is only 6 vacancy advertised.
Yes, ma'am.
One of you has no concern with this advertisement.
But at the
And
same
you are challenging the
this
advertisement.
is my contention is only with respect to the expenditure that shall be borne to bear the salary expenditures.
So you are only concerned with the expenditure.
Yes, ma'am.
Okay.
Because there is already.
You don't need to. How are you concerned with the expenditure? How much
Because-
of tax do you pay?
Because I come under the.
That's right. You don't pay any tax, and you are concerned with the expenditure of the state.
Because they are not in a position. In the last 15 years, I joined to the
You
post
don't
of the
need,
account.
just a moment. Challenging the process of recruitment,
Yes, ma'am.
the litigant need not worry about the exchequer, right? If they recruit, they'll have to make their payment.
Lady,
So they will
because
take care. They must have
this-
seen their
this
finances.
places
before
me at the
advertisement.
mercy of the department whenever and at whatever time they feel that they have a rival pool
You
of
had
trained.
your appointment only for 1 year. Where is your extension letter?
The extension letter I can annex my letter.
Where is it?
I can annex my letter.
We do not know. Your pleadings are itself not complete. We do not know.
So kindly give me time, so Malady, of week's time I'll annex all those letters and whatever the
See,
queries.
we will not enter into this kind of a
I understand.
recruitment process. We are not going to
Your
see.
leadership, may I plead?
Yes.
In the judgment passed by this honorable court in WPS 7401/2019, dated 24/3/2022, it is clearly been quoted in paragraph 8. The judgment. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, it is observed that the petitioners have not produced or placed on record any scheme for regularization of persons employed under Magnera. It is not in dispute that such persons are governed by the Act, namely Mahatma Gandhi National Rural Employment Guarantee Act 2005. It is sufficient to observe that if ever the respondents come up with any such scheme for regularization of Manrega employees, they cannot be arbitrary and selective. If any such occasion arises later, the petitioners may have their remedy in accordance with law.
And in the writ petition,
Yes,
you just see the grounds that you are facing.
yes.
You are seeking regularization only. This is what your ground is.
No, that is
You want to
not
give
my
up that?
prayer, but I'm not seeking regularization of my.
That
post.
is you
But-
say that this advertisement is under challenge because of these grounds.
Yes.
See, that is essentially
in the-
regularization.
So in this particular judgment that I'm relying, that the majority of which have been taken as a ground, the Supreme Court in the judgment has categorically said in the paragraph 5 itself, if I may read to this honorable court,
Which Supreme Court judgment?
the Naren Kumar Tiwari judgment.
So, the
The
moment you
state
come
cannot be
to the
allowed-
moment you go to Naren Kumar Tiwari judgment, it is regularization.
No, there is also clear indication and direction that the state cannot be permitted to perpetuate on irregularity.
Okay, kindly give me that paragraph.
Para 5, my lady.
You have got that judgment here?
I have another copy also.
Para number
5.
5.
Para number 5 to 12, the complete essence has been
5 to
there.
12. Okay.
Yes,
You are relying upon para
5 to 12.
5 to 12, and you want the same relief as that of Naren Kumar Tiwari.
No, I'm not seeking regularization because that is not my prayer. I shall not exceed what has had been pleaded beyond my pleadings. What I am seeking is that state cannot be allowed to perpetuate on illegality, And for that,
What illegality they have committed that you are saying
sorry, I
that?
beg your pardon, there's a slip of tongue. Irregularity of the
No,
appointment.
what irregularity? Whose appointment is irregular? Your appointment is irregular?
Subsequently, it will be interfered. They are in a position to create a rival
You see,
pool of
when you
employees.
say that the state cannot perpetuate irregularity, then you have to point out which irregularity they are perpetuating by issuance of this advertisement.
Because by way of this judgment, it was a clear direction, particularly to the state of the Jharkhand. They have passed the regularization rules 2015, amended 2019, and subsequently they have not implemented it.
That's it.
Yes, my lady. May I read para 5 to 12? The
I
relevant
read it. You read it if you want to read it. Read it. 5 to 12.
Yes, ma'am.
It's 3 pages. You want to read it in the open court? You just tell us which is specifically you want to read. We have read it
Specifically,
many
I'll-
times.
yes,
We
ma'am.
have read it many times. So you
I'll
can just
specifically read to para 5. I'll specifically read para 5, 7, 8 and 10.
continue, please.
There's a small paragraph.
Hmm.
The decision in Umadevi was intended to put a full stop to the somewhat pernicious practice of irregularity or illegally appointing daily wage workers and continuing with them indefinitely. In fact, in para 49 of the report, it was pointed out that the rule of law requires appointment to be made in a constitutional manner, and the state cannot be permitted to perpetuate on an irregularity in the matter of public employment, which would adversely affect those who could be employed in terms of constitutional scheme. It is for this reason that the concept of one-time measure and a cut-off date was introduced in the hope and expectation that state would cease and desist from making irregular or illegal appointments and instead make appointments on a regular basis.
That's right. Then there is the quotation. Okay.
Yes, ma'am.
You come to
And
para
then please come to
7, 8.
7. My lady may come directly to para 10. 7 and 8 in the same light of the para 5, what has been stated above. Under the circumstances, we are of the view that regularization rules must be given a pragmatic interpretation, and the appellants, if they have completed 10 years of service on the date of promulgation of the regularization rules, ought to be given the benefit of the service rendered by them. And if they have completed 10 years of service, they should be regularized unless there is a valid objection to their regularization, like the misconduct etc. Para 12, the small paragraph, we may add that it would be worthwhile for the state of the Jharkhand to henceforth consider making regular appointments only and dropping the idea of making irregular appointments so as to short-circuit the process of regular appointments. My lord, my lady, that's ad hoc appointments are in the nature of irregular appointment. That is for the
So
period
your
of 1.
appointment is ad hoc.
Yes, my appointment is also ad hoc.
That is why they are coming up with regular advertisement.
This is not a regular. This is for the ad hoc appointment.
Anyways, we have seen this. What other this judgment you are relying upon? This one. This is 1021.
Yes, ma'am.
Which paragraph are you relying upon? Which paragraph? You say that this was dealing with Manrega also.
Yes.
Where do I get that?
In particular, this has not pointed, but there has been a submission to that effect
We
in
do
para
not.
5. In para 5, there has been a particular submission from the concerned council.
Has the Honorable Court held that for Manrega also this judgment and this kind of scheme?
This has not categorically stated any particular department. This has stated all the employees that have been appointed by the state government on the ad hoc basis.
So therefore, as per this judgment, you say that Manrega is also covered.
Yes, madam.
In my judgment, what I have stated, I have only stated that if there is any scheme for regularization, it will be considered.
My lady, that
It's in effect the same thing,
yes, ma'am.
but that cannot be a ground to challenge the advertisement.
Because this will create a rival pool. Because in para 26 of the judgment, the instant judgment.
Firstly, your relief is not for regularization.
No, my
So you
relief is
need not worry about regularization.
No, my
That is not your relief.
no, not my relief.
You are challenging the advertisement
Yes, my lady.
for only 6 posts.
Yes, my lady, because this will ultimately create a rival pool of contenders, and subsequently this will add to the litigation process, which has been observed in para
So you are
26.
concerned with the rival pool.
Yes, my lady, that is there. That is there, and it will for the same set of employees. I mean, the same amount of the resources that was available for the dispense or bearing the salary expenditure. More number of people will be vying for it.
That's
And subsequently, if I am regularized, or for that matter, if I am removed from the services, this will be only on the basis because over a period of time they will create a similar set of employee, and after 15
I heard
rendering.
you. Your is that relief has already been granted to them.
May I plead?
One. Yes. What else you want to say?
It is a centrally sponsored scheme, first of all. The continuity of the scheme depends on the decision of central government. That is why there is the provision of contractual employment of Magnera staffs in the rules framed by state government by resolution number so and so. I have that resolution number with me. If your leadership permits, I can bring on record.
No counter is required. You just tell us. You have got that rule?
No.
No. Anyways, it is governed by the Manrega Act. It is governed by the Manrega Act. Yes or no?
I'm not aware of.
You are not aware about the Act.
No, I'm aware of the act, but I'm
It
not
is
aware
governed by Manrega Act.
the scheme. The scheme is definitely Manrega. The act is here to stay. Many of the appointment that has been made is made under the act.
That's right.
So until unless there
We'll
is
see that. Just hold on. Yes.
And your leadership, it is recruited on contractual basis. It is pertinent to mention here that for the smooth execution and monitoring of Magnera's scheme, the vacant seats of this field staff are to be filled. That is why with the resolution number 1996 of 20.07.2023, the directions given by the this deputy commissioner of Magnera's scheme to quash the memo number so and so, that is not acceptable.
That's it.
Yes.
there's a notification also by the government of Himachal Pradesh where they have
We are
given
not
them.
concerned with Himachal Pradesh.
They have regularized the pay scale, and they have extended the service to that of the 60 years.
Are we governed by that?
No. I'm
So
just
let's forget.
trying to persuade the court in that way.
You have got that notification of the state government?
Not now, Your Lordship. I can bring it.
You don't have it here.
Uh,
Because you are addressing the court without having the notification in your hand.
Your Lordship, we have got the instructions from the department. That's why.
We'll take care of it. Okay, heard the learned counsel for the parties. This petition has been filed for the following relief. The learned counsel for the petitioner has heavily relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2018 bracket close 8 SCC 238 Narendra Kumar Tiwari versus State of Jharkhand. Paragraph number 5, 7 to 10.
And 12 also.
7 to 12. The learned counsel, while referring to this judgment, has submitted that the Honorable Supreme Court has deprecated the practice of making ad hoc appointment by the state. And also the practice of irregular and illegal appointment of daily wagers and continuing them indefinitely. The learned counsel submits that the petitioner number 1 has been working as Gram Rojgar Sevak, and petitioner number 2 was working as account assistant. Under Manrega Act 2005, again sanctioned post, and the name of the petitioners appeared in annexure 2 to the writ petition. Both the petitioners are there.
No. This is petition number 2 in annexure 2 and the appointment letter of the petition number 1 in annexure 1.
Okay. The petition, the appointment letter of petition number 1 is contained at annexure 1. And so far as petitioner number 2 is concerned, his name is in annexure 2. Annexure 1 has been issued by the Deputy Commissioner cum District Program Officer Dhanbad, and annexure 2 has been issued by the Office of Commissioner North Chotanagpur Division, Hazaribagh, which contains a list of 26 persons. Annexure 2 is dated 8/5/2008. The Learned Counsel has submitted that the petitioner has challenged the advertisement issued by the respondents for the purposes of recruitment, for the purposes of induction of vacancies and has fairly submitted that, and fairly submitted on a query of this court that no vacancy with regard to Gram Rojgar Sevak has been advertised in the incoming advertisement. It is only the advertisement inter alia relating to accounts assistant, for which vacancy of 6 posts has been advertised. The Learned Counsel submits that by virtue of this recruitment, parallel right will be created in favor of the persons who would be recruited, and such recruitment is not in accordance with law. The Learned Counsel has fairly submitted that in the present writ petition, the petitioner has not sought any relief for regularization. He has, however, referred to a judgment passed by this court in WPS number 1021 of 2020 and other analogous cases, and has referred to para 5 thereof to submit that the matter regarding regularization has been considered in the said judgment, as the petitioners were also working under Manrega scheme 2005. The Learned Counsel, appearing on behalf of the respondents while opposing the prayer of the petitioner, has submitted that, has referred to judgment passed by this court in WPS number 7401 of 2019, wherein this court has held that there being no scheme for regularization for Manrega employees, therefore the relief to grant relief to issue mandamus for regularization was denied, And it was also observed that if the government comes up with any such scheme for Manrega employees, then the case can be considered in accordance with the scheme. The Learned Counsel has further submitted that the scheme under Manrega, the employment under Manrega is not an employment under the state government, rather it's an employment under the scheme and purely contractual in nature, governed by the Manrega Act of 2005. He has submitted that it is a scheme sponsored by the central government and substantially financed by the central government. And accordingly, he submits that the judgment relied upon by the petitioner in the case of Naren Nath Tiwari, as well as in the Naren Nath Tiwari has no applicability. He has also submitted that the judgment passed in the case of WPS number 1021 of 2020 also does not apply, as the petitioner is not seeking any regularization from this court. So far as advertisement is concerned, he submits that only the vacant posts have been advertised, and it is not clear as to how the petitioner is prejudiced by the advertisement of the vacant post. That's it.
Lady, please let them bring these resolutions on record,
Nothing
because how
is
would we know that whether they are interpreting the resolution in the right manner or not?
We'll see.
Because we are not in receipt of that particular resolution.
That's right. That's all.
Yes, ma'am.
The arguments are concluded. Post this case for judgment on 22nd February.
Lady, may I also quote the relevant para of those judgments, the 15.1 2024 of the coordinate bench.
Sorry.
The relevant paras
Of
of the 15.1 2024 of the coordinate bench judgment.
15.1?
2024, the coordinate bench judgment period. 1021 of 2020.
You have referred to the paragraph. Which
Yes.
all of paragraph are you referring to?
I'm referring
Apart from 5?
apart from 5, I'm referring to 28, 31, 32.
Okay.
Should I give it in writing to you?
No, you just tell us. We'll give
28, 31.
it. जहाँ पे ये लिखे हैं ना 1021, he has referred to paragraph number 28,
31,
31,
32,
32,
34,
34,
35, 37,
35, 37,
41 and 42.
41 and 42. To submit what? That you are entitled for regularization.
No, that apart from without regularization, they should not go for the fresh appointments.
To submit that unless there is regularization of the petitioners, the respondent should not go for fresh appointment. Right?
Yes.
The whole problem in this court is that whenever one order is passed by one court, you do not place it in another court. Isn't it? And you are happy with that. Let there be conflicting orders of various benches and let the advocates make merry out of it. Isn't it? This is what you are doing. Every day we are coming across conflicting orders of single benches. Every day we are coming across. Had he claimed any plea of regularization, then I would have referred to a larger bench. Because he is not claiming any relief of regularization, so we are not bothered about it. But it is absolutely, you don't place the order. This is also there in the live law, but still you don't place because there is no study at your end. Or maybe you are intentionally doing it.
Your Lordship, this issue has already been set aside by this honorable court only. WPS 7401.
No, 7401 order has not been placed in the batch of cases which has been disposed of relating to Manrega. You don't place it. %50 litigation of Jharkhand High Court is like this. At least in service matters. Rest of the matters I cannot say. But at least in service matters, 50% of the litigation is based on suppression by either of the parties. You should place the orders, isn't it? Whatever may be. If the concerned judge, does not agree, he can certainly cite that I don't agree or whatever. But you don't cite it. Poor quality of assistance. Right? So we must call them.
From daily list for final result item 1, WPS 3315 of 2023.
This has been wrongly placed in the first half. It will be taken up in the second half. We take up final disposal matters in the second. We'll take up the second half.
Okay.
The list of sorry.
It was also been heard by
I just want to know the list of dates and synopsis has been filed.
synopsis is there.
No, that synopsis is not sufficient. After the counter affidavit, you should file a list.
If your lordship will see the 19/12/23 order summarized, in order it has been already summarized.
It is not like this. You see, that was an order passed by honorable
That
court bench.
factual aspect and
No,
date
no.
has been summarized.
You think that synopsis is not required? Will you file your synopsis?
File related with-
Please file it. Not tomorrow. I'll post it on the next date. But you
Yes,
file your. I will record that he is not interested in filing
This is
synopsis.
that I should give, but date wise I will give.
Then WPS number 3315 of 2023. Counsel for the parties are present. The pleadings are complete. Counsel for the parties are directed to file short synopsis, list of dates, and the judgments which they seek to rely upon.
Then I already will, how that I will enclose in the written. Whatsoever I have relied.
And the judgment which they seek to rely upon. You can just give the reference and you just mention that it is
Yeah, that I
in
will.
your synopsis. You just give the
One
reference
page.
and mention that it is there.
Yes, I understood you. One
by-
page is.
27th February 2024. Post on 28th February 2024. You can do it by 23rd? Okay, by 23rd February 2024. Post on 27th February 2024 under the heading for final disposal to be taken up at 2:15. Yes.
27th.
It will come on 27th.
Simple issue is that
215 not seconded.
2:15 will come up.
250.
Corporate filing item 20, WPS 7083 of 2023.
There are so many documents annexed, so we have to take care of whatever you have annexed to the
My lord, I will give this.
Yes, petitioner. What is it?
Yes, may it please your lordships, my lord, the petitioners are elementary teachers in graduate trained scale. They were directly appointed in the year 2015, my lord. They were directly appointed in the year 2015 pursuant to the new appointment rules 2012. Earlier, my lord, no direct appointment was made in graduate trained scale. Only matric trained scale and then promotion to graduate trained scale and then headmaster. Broadly, my lords, in elementary cadre, there are 3 scales, my lord.
Counter affidavit filed.
Pardon? Counter not filed, my lord.
Counsel for the parties are present.
My lord,
Counsel for the
one
respondents
prayer
is
I am
directed
making.
to seek instructions and file a counter affidavit in the present case. How much time do you need?
Your Ladyship, I am appealing on behalf of the interveners, Your Lordship. I have filed IE number 822 of 2024. The gradation which the petition has challenged. Our names are appearing in that gradation list, Your Lordship. So therefore, Lordship, Lordship, they have filed this.
Where is the state? IA number 822 of 2024. The learned counsel for the intervener submits that the intervener petition that the name of interveners is appearing in the gradation list, which is subject matter of consideration in the present case, and therefore the intervener application has been filed. He submits that the order which may be passed in the present case will have a direct bearing on the interveners. Any objection?
No, my lords, one prayer I want.
No, I just to intervention.
Yes, to intervention.
The learned counsel for the petitioner has no serious objection to the prayer for intervention. State
Your Ladyship, I'll inform.
intervention. The learned counsel for the
I'll inform them.
inform whom?
Ladyship, this is not my.
The counsel for the state is absent. Considering the aforesaid submissions, IA number 822 of 24 is hereby allowed. The interveners are permitted to be added as respondent number.
From 18, it will start, Lordship. Total interveners are 6 in numbers.
Respondent number 6 to
It will start
6 to
from
11.
6. It will start
6
from
to 11.
6 to 11.
The counsel for the intervener is directed to carry out the necessary amendments in the cost title during the course of the day in reading. Right. Counsel for the, you will file your counter.
Yes, Lordship.
Counsel for the newly added respondents. Number 6 to 11. Prays for and is granted time till 28 March 24 to seek instructions and file a counter affidavit in the present case. The state shall also file the counter affidavit by 28th March. The counter affidavit should be filed by the principal secretary or the director. Principal secretary should file it.
Principal Secretary, I have impugned his
Should
order,
be
my lords.
filed by respondent number 2.
Your Ladyship.
Now, my lords, I will seek indulgence for 5 minutes, my lords, because there is prayer for stay also. What has been done, my lord, that from grade 4, that is graduate trained scale, promotion to head master is done, my lord. After they fulfill 5 years of qualifying service in grade 4.
What is the urgency of a stay?
Yes, urgency.
What stay are you
just
seeking?
In 2 minutes, I will show, my lord.
You tell us a prayer. What is your prayer for stay?
My
Where
lord,
is your prayer for stay?
that's- Yes, my lords, I have made a prayer.
What is your prayer for stay? There is no separate interlocutory application for stay.
My lords, but I have mentioned in the prayer itself, prayer portion itself, my lords.
What is the stay? Which
Yes. My lords, 2 minutes I will take. My lords, what they have done, that the rule, 1993 rules, it provides for promotion. It has been duly adapted by state of Jharkhand. It provides, my lord, 5 years of qualifying service for promotion to
we
headmaster.
are not hearing the main matters.
No,
sir.
main matter.
Please tell us that what is it going to happen
Yes.
in the meantime.
Yes. Now this.
Are you going to be superseded?
Yes, my
Who
lord,
is going
very
to
correct.
supersede
Yes, I am being superseded.
By whom?
Because by the impugned order by the private.
Private respondents, you did not even make them a party.
No, my lord, I have challenged the order of the secretary for the reason that by executive order, he has said that 10 years of qualifying years of service will be necessary for us and 5 years for them. The promotion rules provide only 5 years, my lord.
When is the meeting for promotion is going to be?
My lord, it is going on. They have published the list. In consequence, my lords.
You see, you have to file a separate petition for stay. We are just putting it on 21st, post on 21st March.
My lords,
Under
then
the
the entire matter will become infructuous.
It
If
will
my
not,
lords,
it can't become infructuous. Any order will be certainly subject
my
to the
lord,
result of this case.
it is in the pipeline in pursuance of a wrong order of the
We will see
secretary.
that. We will see that. We will see that. They are already here before us. There is no problem
No,
about
my
it.
lord, but their role comes next, my lord. If my lord, this is very important because, my lord, by an executive order,
For
by
orders
an,
item 21, the LPS 3158
my
of
lord, said it
2023.
may be subject to outcome. It will
We
become,
will
my
not
lord,
say anything.
futile.
It goes without saying only. You don't need
Lord, I
to.
appear for the
My lord, then a date prior, my lord.
You were absent.
Lord,
After the order, you come and say that you are appearing.
just now I have come, Lord, I was
You can appearance record kariye. Nobody appears delete.
My lord, sir, an earlier date may be given because, my lord, this is very important. If my lord will spare 5 minutes,
It's
my
just
lord,
4 weeks time. I'm not giving.
my
I'm
lord,
fixing a
they
date
will
also.
make headmaster. They will come over our head. My lord,
The moment it happens, you come and file your interlocutory application first.
जो वो सेक्रेटरी मन से रूल्स को वायलेट कर रहे हैं, वो कहते हैं 10 साल और बोलते क्या है कि रूल बनाया जाएगा, रूल नहीं है, तो ये तो अनबिलीवेबल है. How
See, if the process is so vitiated and if it is absolutely arbitrary, don't worry, we will set aside the entire process. We will set aside the very letter itself and all the consequences will follow. There is no problem about it.
Yes, that
But
is
let them
very
file their
correct.
counter affidavit. The interveners have come, they are directly affected. You did not even make them party. Let them file a counter affidavit. Let the state also file a counter affidavit.
I am purely concerned with the order of secretary, my lord.
We will see.
ये your executive
No, we
order
will
से.
not pass any order without hearing the secretary.
But my lord, if my lord, the balance of convenience and the law says, I have
will
got
see
the
that.
judgment of Supreme Court
That's
also,
right,
my lord.
that's right. We have
It
to
says that
let the matter come up. In the meantime, if any notification is issued, if any decision is taken, you come with your
it will become
interlocutory
headmaster, it will become clumsy.
No, it
and
will
my
not
lord,
become clumsy. That we will take care of.
Then
Next
I am
call.
playing
Who
a
is
date.
there for the petitioner in this case, please?
Item 21.
An earlier date I was praying, my lords.
Just
थोड़ा सा पहले दे दिया जाता.
Least, it's the very short date we are getting.
मार्च काफी हो गया.
Just 4 weeks away. Yes.
Come under the heading for orders earlier, private respondent number 5 to 10 were issued notices. Check the file 5, 6, 5, 7, 8, 9, 10 have filed their wakalatnama. 6 has still, if you not ladyship, may kindly have ordered it 11/1/2024. Order number 6. This was the last order. It has been reported by the office that the notices issued.
Fresh notices have gone?
Yes, through department. This
But
order says,
SR has not been received.
this order states that the department had to issue notice. Via department, the notice.
No.
Yes, it's 11/1/2024. May kindly have.
Kindly read that.
Yes, your ladyship.
That it has to go by the department.
Second paragraph. Under the said circumstances, let fresh notices be issued to the respond number 6 and 7 to ordinary process to be served to them through respond number 3, for which requisite must be filed within.
Where is respondent number 3?
We have filed the requisite, your ladyship. Respond number 3 is road construction department secretary.
So you file your affidavit regarding service of notice upon respond number 6.
I will file.
Learned counsel for the parties are present. The learned counsel has referred to order dated 11/1/2024 to submit that the notice was to be served upon respondent number 6 through respondent number 3. The learned
6
counsel
and
for the
7,
state.
7 is filed the wakalatnama. 3, 6 has not yet filed.
That's it. The learned counsel for the respondent state is directed to seek instructions and file an affidavit regarding service of notice upon respondent number 6.
I appeal for 7, 8, 9 and 10.
Give your appearance. You have filed your counter?
No, your lordship, I need 4 weeks time to file counter.
Otherwise the state has filed counter?
Yes, ladyship.
The private respondents seek 4 weeks time to file a counter affidavit in the present case. Pose this case on 20th March 2024 under the heading for admission. In the meantime, the affidavit of the state as well as the counter affidavit of private respondent will be filed.
For case filing, item 22, WPS 3048 of 2023.
Yes, petitioner. Who is for the respondents?
I am appearing on respondent lordship, and it appears that JEPC also a party because the case related to para teacher.
Okay. They are seeking payment of admitted dues. If it is admitted, they pay it. Who will pay them? They have filed any representation before anybody?
Yes, representation is there, lordship.
Where?
Case 31.
They have filed it before whom?
DSC District Superintendent of Education. So sometime we will lordship, we will take instruction. Last day lordship has directed to file counter lordship. That has not been filed.
We'll ask them to move the authority.
Lordship.
District Superintendent of Education come District Programmer. Respond number 4, right? Who is for the petitioner? The counsel is absent. Nobody appears on behalf of the petitioner. From the perusal of the writ petition, it appears that a prayer has been made seeking a mandamus upon the respondents to pay the admitted dues honorarium of the petitioner from the month of February 2021. The records of the case indicate that the petitioner has been represented before the respondent number 4, but no decision has been taken. By the order dated 31/2024, time was granted to file counter affidavit, but no counter affidavit has been filed in the present case. It is the case of the petitioner that a village education committee, Pachmo, organized a meeting for selection of second within that community, para teachers, on 21/9/2008. And the name of the petitioner was considered on the basis of the education qualification. And after selection, his name was recommended on 30, recommended and approved by district level committee. And thereafter the petitioner has been continuously discharging the duty up to the satisfaction of the authorities. The petitioner also attended the training for 15 days at upgraded middle school, Pathalgadda, during the period from 13/1/2009 to 27/1/2009. The grievances that, in spite of discharging the duties, the petitioner is not being paid the honorarium. No adverse order denying the claim of the petitioner has been placed on record of this writ petition. Considering the nature of the petition and the relief paid, this court is of the view that the grievance of the petitioner is required to be looked into by the respondent number 4 at the first instance. or respond number 3? DC?
4 Lordship.
4? Respond number 4.
Because he filed a petition before respondent number 4.
But he is not taking any action.
3 and 4 both will be typed.
Can be taken care of by respondent number 3
3 and 4.
in view of the fact that the respondent number 4 has not taken care of the grievance of the petitioner. Accordingly, this petition is disposed of by enabling the petitioner to file a representation with supporting documents and the records of this case before respondent number 3 within a period of 1 month from today upon filing of such representation. The respondent number 3 is directed to grant an opportunity of hearing to the petitioner as well as respondent number 4 and 5, so that the records are placed before the respondent number 3 for taking appropriate decision. A reasoned order be passed after granting an opportunity of hearing within a period of 4 weeks from the date of filing of the representation, in accordance with law and considering the applicable circulars and guidelines with regard to the claim of the petitioner. The reasoned order be communicated to the petitioner through speed post. If the petitioner is entitled to one or the other benefit arising out of the reasoned order, the respondent number 3 shall also take steps so that the admissible amount is paid to the petitioner within a period of 1 month from the date of the reasoned order. This petition is accordingly disposed of.
Item 23, WPS 3864 of 2023.
One of the requirements is meta threats to the punishment of dismissal from service.
Sorry?
And they have also to bring on the, in the meantime, the pendency of this petition, the petitioner has been acquitted in the criminal case. For the same set of criminal case, that is the cause of the departmental proceeding.
So that acquittal order you want to bring on record?
Yes, no, I will bring on record.
So if you have been acquitted, then that acquittal part has to be taken care of by the authorities only. We will not scrutinize, are we?
Yes, that must be taken care of by the respondent, not same set of offense, for the same cause of action.
Same set of evidence
Same,
also?
same set of evidence.
Same set of evidences
Yes,
also?
the persons who are.
Where is the order?
The certified number by filing.
The learned counsel for the parties are present. The learned counsel for the petitioner has submitted that on the same set of charges, there has been departmental proceedings as well as criminal case, and in the criminal case, the petitioner has been acquitted. How much time will you take to bring it
2
on?
weeks time will be sufficient, but I have been after also, but I will file. 2 weeks time will be sufficient.
You have drafted it, you will file it. For that, you need 2 weeks time.
Your Ladyship, our counter is ready to be filing.
The counsel for the petitioner prays for and is allowed time till 4th of March 24 to file a supplementary affidavit bringing on record the order of acquittal, which has been produced before this court for perusal. Let a copy of this order be immediately handed over by the petitioner to the counsel for the respondents. The respondents are directed to file a counter affidavit by 5th of March, post on 6th of March 24 under the heading for final disposal. इसको दे दीजिए, इसका एक कॉपी यहाँ भेज बना दीजिए. You see, if there is an order of acquittal, then it is prima facie for them to consider before we start considering in 226, isn't it?
Yes, in addition that we have to see that how much time.
No, that you will have to see. And after you scrutinize and see whatever is the finding, then only there will be a fresh cause of action to move this way, isn't it? So this is what I propose. I'll remit it back to you for consideration, subject to what ultimately you have to see.
इसका एक कॉपी दे दीजिए.
Which one? You want your appearance to be recorded? I've disposed of the matter with the direction that they will consider your grievance and pay the related dues immediately. Should I record your appearance? Appearance. Give your memo. Record his appearance.
Item 24, WPS 4638 of 2023.
Yes, petitioner.
This counter has been filed.
So, counsel for the parties are present. Counsel for the petitioner prays for and is granted time till 27th February to file a rejoinder to the counter affidavit. Post this case on 28th. 28
एक दिन आगे पीछे कुछ कर दी, खाली 28 को छोड़ दो.
28 को छोड़ कर 28 के बाद 4 तारीख को 4th of March.
5 मार्च कर दीजिए खाली. 4 को हम कोलकाता में, इसलिए this is
It's
unreasonable
good.
prayer. This is
It's
unreasonable.
good that advocates from Jharkhand are appearing all over India.
माइनस 5 को या 6 को या मतलब
You
28
appear online also?
28 और 4 को खाली छोड़ दीजिए ना.
5th of March.
हाँ ठीक है.
Under heading for final disposal?
Yes, ma'am.
What is the matter?
Matter relates to the post of additional professor. I am promoted to that post. My point is that there is no post of additional professor in RIMS. It is only the professor. So the nomenclature has to be corrected by them, and they have done it in the past also.
Okay. Where is the counsel for RIMS?
I'm appearing for RIMS.
They are appearing. So what is your case in
The
the
regulation 2014 says that there will not be promotion will begin without linkage to any vacancy. Without linkage to any.
So there was no vacancy.
Without linkage to vacancy, only the particular percentage will be promoted after completion of particular period. If they have completed 3 years of service in the addition in the associate professor, they will be given associate additional professor. Without any linkage to vacancy, even if there is vacancy or not, they have to be promoted. That is the regulation of 2014. Earlier they have availed.
They have given the instance of earlier occasions. How do you distinguish?
Earlier the petitioner himself has availed that under that rule that particular percentage, and he got the promoted as associate professor. Now he is promoted as additional professor. Now he is claiming as there is no vacancy, as there is no sanctioned post for additional professor in that particular department.
So his designation should
be professor. Earlier we have considered members because at that time there were no professors in 13 departments members, and because
So how will that make a difference? It will make a difference. Let him enjoy the designation at least.
No, the pay scale, particular pay scale was given for additional professor.
Pay scale will be different.
My loss.
You have highlighted this in the counter affidavit.
My loss.
Will you file your short synopsis? Counsels to file their short synopsis, list of dates, and the judgments which is to rely upon by court.
Item 25, WPS 4674 of the 2023.
Yes, petitioner.
May I please observe that the order 2/1/2024 has not been complied with. The counter affidavit has not been filed. The prayer is, my lord, either to pay the financial benefit or to promote, and they change the, my lord, nomenclature, because they all have been appointed as psychiatric social worker. The next promotional avenue as per the scheme is assistant professor. So I have also given the chart, paragraph 7. They all are entitled, they are working for last 18 years, so they cannot deny me. If they are not giving the promotion, at least they have to give them not as a assured career progression.
Who's
And
for
that-
the respondents?
No, impasse, my lord, and this is.
Have you
this-
filed your counter?
We have not filed the counter.
So-
But we have to mention that they are asking for promotion, but they have not mentioned where the scheme is, what are the regulations.
You don't want to file a counter affidavit.
We will file.
You come up with the scheme or rules or whatever is applicable on them. You are mighty state, right? You must be knowing your rules. Or you say that there is no such rule. Okay. Right? You produce the applicable rules.
My lord,
You seek instructions and file the counter affidavit. And I will remember that if there is no rule, you should say that there is no rule. Applicable rules you produce.
How could the paragraph 11, my lord, I have also given that. It was approved by the
Paragraph
Supreme
11,
Court.
you
my lord.
forget it. They will annex it in their
Lord,
counter.
it has been approved by the Supreme Court also, that is scheme.
The learned counsel for the parties are present. Counsel for the respondents. What's your name, madam?
Ayushri.
Ayushri.
Yes, ma'am.
Ayushri. MS Ayushri. Submits that the petitioners have not referred to the applicable rules in the writ petition. However, no counter affidavit has been filed pursuant to order dated 2/1/2020. The counsel for the respondents is granted time till 4th of March to file the required counter affidavit. The counter affidavit should enclose the applicable rules, norms, etc., which may be applicable to the petitioners for grant of promotion. And if there are no rules, the counter affidavit should also indicate specifically about the existence or non-existence of it. Right? Rejoinder, if any, I can just post it on 6th.
Yes, my lord, in the meantime, I will also, my lord, file, my lord, the notes, my lord, and since paragraph 11, I have given a specific statement. The rule which they are saying that there
Let
is
them
no.
annex it, they will annex it. Let
Yes,
them
yes.
do some homework
Yes, obliged.
on 6th of March under the heading for admission.
Item 26, WPS 4827 of 2023.
On last occasion, Lordship may see the last order dated 13/2/2024. Lordship has done in para 3. Yes.
Where is that? They have annexed it.
Yes, Lordship.
There is one order, letter number 1237 dated 11/6/2015.
They have not filed counter affidavit. Counter has not been filed. The state has filed counter affidavit and they have said the housing board will file the detailed counter affidavit.
You see, have you seen order dated 13 February 24? It was passed in your presence, madam.
I have given them.
You don't take out the print of the, or maybe that you don't keep your soft copies also ready.
I will bring out recording. Page 73 of the writ petition has been brought up to the office only. Another claim of petitioner has been rejected by the Jharkhand Housing Board. By the petitioner, it appears that the will be discussed by petitioner.
You bring it on record.
I
If
will
his
bring-
claim has already been rejected, there is no question of fresh consideration.
Respondent को direction नहीं है, but I will bring in protocol.
Lordship, it requires fresh consideration, Lordship, because Lordship, just for a moment,
No.
page 73.
No, we will see that. The
Let me,
learned counsel for
I
the
will do one thing.
respondents are
Let
present.
me file a counter. I will annex the
Yes,
that letter.
the learned counsel for the parties are present. The learned counsel appearing on behalf of the respondent housing board prays for and is granted time till 4th of March 24 to file a counter affidavit in the present case. Rejoinder by 11th, post on 13th of March under the heading for final disposal.
13 की जगह 14 या 12 कर दे रहे हैं.
You are not here. You are
No,
not
I am
here.
here, Lordship, but 13.
13th is a very auspicious day. Don't worry about it.
The petitioner is
Item
fighting for the
27.
last 10 years.
Item 27, WPS 5366 of 2023.
The disclosure of the petitioner is not complete in the report.
I had asked him on phone last week. I had asked him on phone, this is the remark of the court. Only he said that is not in my position. I have attached all the documents which was in my position.
Yes, petitioner. PF.
This is for payment of GPF for certain period. It was 1984, August 1984 to February 85, and then March 2000 to June 2000. Ladyship receives consistently this petitioner from 2001, seeking the details and calculations, and then, but no reply has been given by either by JPF, Directorate GPF, by Government of Bihar.
Your provident fund amount was being deducted from your account.
That is a specific claim that the petitioner was appointed in 84, and since then the provident fund was deducted, and now he is also
You have
saying
annexed the payslips.
payslip is
You
not.
must be having all the payslips because 84 document. How will they verify?
GPF को तो पता होगा कैलकुलेशन, हमारा स्टेटमेंट ऑफ अकाउंट होगा उसके पास प्रोड्यूस
आपके
कर।
पास कुछ नहीं है, पेस्लिप भी नहीं है।
हमारे पास
84 का claim. Just appreciate that. The claim is relating to the year 1984. You make a statement that it was being deducted. State of Bihar has filed a counter affidavit.
No.
You file your counter affidavit.
fact,
Verify the
Jharkhand-
records. If the records are there, it's okay. It's not there, we cannot issue a mandamus notice.
GPF is also GPF तो party है डायरेक्टर GPF बिहार एंड झारखंड as well. वो तो
Who
specifically
is
बता
there? Who appears for them? Who appears for
जीपी
the
बिहार के
director?
तो हम करेंगे
The director GPF.
जी वो हम करेंगे
You will take care.
बिहार के लिए हम करेंगे
counter affidavit of government of Jharkhand.
This is for Bihar and Jharkhand both.
Period is
Respondent number 6 is for Bihar and Jharkhand both.
No, respondent number 6 is for Bihar. Respondent number 3 GPF, director GPF is for Jharkhand.
Counter affidavit has been filed from respondent number 3.
That is the state. Respondent number 2 only.
You will appear for director GPF also?
Director GPF is to be represented
Separately.
Counter affidavit by the state.
I'll just check.
Counter affidavit by the state says that they are also requesting the director GPF to provide the information, but they are not giving. Jharkhand को भी लिखे हैं, बिहार को भी लिखे हैं.
WPS number 5366 of 2023. The counsel for the petitioner submits that, as per the counter affidavit filed by respondent number 2, they have been representing before respondent number 3 as well as respondent number 6 for giving the details of the deductions in connection with the petitioner, but there is no response. You will file on behalf of respondent number 3 or we have to issue notice?
I think we'll file notice.
Counsel appearing on behalf of the state submits that a specific affidavit, prays for time to file specific affidavit in connection with of the respondent number 3. The learned counsel appearing on behalf of state of Jharkhand submits that he shall file, state of Bihar submits that he shall file affidavit on behalf of respondent number 4, 5 and 6. Let the supplementary counter affidavit on behalf of let the aforesaid counter affidavits be filed by 11th March,
4 weeks
18th March, by 18th of March 24, rejoinder by 27th March, post on 1st of April 24, under the heading for final disposal. You verify the records before you file your affidavit. All the accounts, the statements, and annex it along with the counter affidavit, so that if he has anything, it has to be taken care of.
Just next date is
1st April.
Item 28, WPS 5590 of 2023.
Yes, petitioner.
Please follow.
for direction upon the respondents, my lord, to treat or receive the rate of service of the petitioner as regular service in the post of junior assistant grade 2, my lord, with effect from 1st April 1999, my lord, in place of 18/11/2020. As because a similar situated person has been given employment with effect from 1st April 1999, my lord. And prior to this,
And he has been regularized with effect from 1st April 99. Where is that letter?
junior similar situation.
Where is that? Where is that letter?
Prior to condition. Prior to this heat application or petition moved before this honorable court, my lord. Kindly see NHL 14, my lord, the order of this honorable court. Relevant, last paragraph 8, my lord, page 49, my lord. In view of the matter, the respondent, in particular, respondent 4, is directed to consider the case of the petitioner for regularize of the service of the petitioner on the post of junior assistant grade 2 in grade office in the Indian Statistical Institute, as stated, at per which the similarly situated person, namely Srimati Krishna Bhattacharya, has taken an appropriate decision in the matter, taking into consideration the environment made in the rate application and observation made by this court are taken on account of the relevant rule regulations required decision within a period of 3 months.
This Krishna Bhattacharya,
को 99 से प्रयोग किया
where is that order?
गया order is, my lord, annexure 10, page 42. Page 42. And after the order of this honorable court, my lord, the respondent preferred the appeal, my lord, LPA, my lord. The said has been dismissed, my lord. And petitioner also filed the contempt in this contempt application, my lord. The observation in view of the aforesaid fact, it appears that the order has been complied with. However, liberty is reserved with the petitioner to approve appropriate forum if any other grievance will be subsists. And thereafter, petitioner filed several representations, and last representation dated, my lord, 5/7/2023.
And where is your order of regularization?
My lord, annexure, my lord, 13, my lord, page 46, my lord.
The terms and conditions of your regularization is not same.
Both same, similar.
You are entitled to new pension scheme.
इसीलिए तो पायलट हमको न्यू पेंशन स्कीम में डाल दिया गया, हमारा शिफ्ट होता है तो हम ओल्ड पेंशन स्कीम में आएंगे. I am fully deprived, my lord.
You were appointed on compassionate ground on ad hoc basis.
एड हॉक बेसिस में मतलब उन एडवर्टीजमेंट मतलब टाइम टू टाइम हमारा एक्सटेंशन किया गया, एडवर्टीजमेंट पर हमारा अपॉइंटमेंट हुआ, टाइम टू टाइम एक्सटेंशन किया गया. उनका भी कृष्णा भट्टाचार्य का भी किया
गया. It is mentioned in your order of regularization, wrongly mentioned.
No, ma'am.
In your order of regularization only it is mentioned that you were appointed on compassionate, on extreme compassionate ground on ad hoc basis. It is mentioned in your order.
No, it comes as appointment.
How do you say it is mentioned in your order?
Ma'am, can you see an action?
The third line you just read it. This is your order of regularization. Annexure 13, the third line, was appointed on extreme compassionate ground on ad hoc basis as uncategorized worker.
Ma'am, can you see my annexure?
Have you disputed this? Is it under dispute that you were never appointed on compassionate ground?
No, ma'am.
Where have you stated? where have you stated that you were not appointed on compassionate ground?
After interview, madam, can you see, madam? Paragraph
For
6
compassionate appointment also there has to be an interview. But your order of regularization is indicating that you were appointed on compassionate ground.
Madam, kindly see annexure 1 is the initial appointment, madam. उसमें कहीं लिखेंगे
Need not be there. But this is what is mentioned in your order of appointment, regularization, it is mentioned.
Then I will file the supplementary affidavit, madam, stating that I will never
Who is further
appointed as
respondents? Are they appearing?
Union of India.
Union of India will file the affidavit here. In this case,
Respond number 1.
respond number 1. They are the employees under Union of India.
No, it is.
then the employee of taken guided by Union of India.
Guided by Union of India. Are you covered by CAT?
Madam, no.
Are you sure?
कैट से तो नहीं हो रहा है पहले भी आए हुए हैं
नहीं, पहले आए हुए हैं।
लीग
CAT.
में पहले भी फाइल हुआ है
That's right. I just wanted to know because normally employees of Union of India, I think Indian statistical,
तो
we'll
इस पर भी
figure it out.
हम एग्जामिन कर लेते हैं
एग्जामिन कर लीजिए पहले, ऐसे काउंटर के लिए नहीं बोलूँगा। WPS number 5590 of 23. Counsel for the petitioner seeks adjournment post tomorrow. कल देख लेते हैं, काउंटर करना होगा तो कल कर देंगे, नहीं तो कैट का जुरिस्डिक्शन होगा तो कैट भेज देंगे आपको।
हम इसमें सप्लीमेंट्री भी फाइल कर देंगे।
Not required. आप कल आ जाइए,
मैम
ठीक है? He shall intimate this court as to whether the grievance of the petitioner, as to whether Central Administrative Tribunal has a necessary jurisdiction to consider the grievance of the petitioner.
Ladies, in the last matter minutes, that all the notices will go to the chief. I just statement. They will be represented separately.
You were the stenographer. अभी जो एक ऑर्डर हुआ नोटिस हुआ है स्टेट ऑफ बिहार को फाइल करने के लिए काउंटर, उसमें respond number 3.
Respondent number 3, that is to
Let notice be issued to respond number 3. For
I
which,
just-
where is the counsel for the petitioner?
I will inform Rahul Kamlesh was.
Yes, for which recuses must be filed by Monday.
Right.
Under speed post as well as ordinary process. Office to track speed post delivery.
Item 29, WPS 6204 of 2023.
Regularization matter. Counter has not been filed. The petitioner has approached the Honorable Court for the third time.
There is an impugned order.
Yes.
Let us see the impugned order.
Annexure 18, it is start from page 79, relevant parties on page 87 and 88.
What is the ground of refusal for your regularization?
At that time, Public Service Commission, Bihar Public Service Commission was commissioner. This is the sole.
Sorry? This is the sole reason to refuse regularization?
Yes.
Let us see that. Where is it mentioned?
Page 87.
Page 87. You are?
Sayyid
Sayyid
Naseem and Ram Ashray.
Naseem
petitions.
and Ramash.
There is para 1, para 2 and thereafter. अतः इस मामले में झारखंड सरकार के अधीनस्थ अनियमित रूप से नियुक्त एवं कार्यरत कर्मियों की सेवा नियमित नियमावली 2015 की खंडिका 3 का 3 के उल्लंघन हुआ। साथ ही सैयद नसीम अख्तर के लिपिक सह टंकर की सेवा में रखे जाने के समय उस पद पर नियुक्ति के लिए आयोग ऑब्लिक चयन प्राधिकार बिहार लोक सेवा आयोग कार्यरत था। अतः नियमावली के बिंदु 3 का 9 यह नियम उन पदों पर नियुक्ति के लागू नहीं होगा जिन पदों पर नियुक्ति के लिए आयोग चयन प्राधिकार नियुक्ति के समय कार्यरत है कि आलोक में इनकी सेवा नियमित नहीं की जा सकती है। रामाश्रय यादव के संबंध में उक्त नियमावली के प्रावधान 3 का 3 का उल्लंघन है। इनकी सेवा के संबंध में भी सक्षम प्राधिकारी द्वारा नियुक्ति पत्र निर्गत नहीं किया गया है एवं इनकी सेवा के चयन के समय किसी भी चयन प्रक्रिया का अनुपालन नहीं किया गया है।
So that is as per the circular only. What is the illegality in this order? You show me that this is contrary to the circular.
This is contrary to the direction of Honorable Supreme Court.
Which? Tell us. The Honorable Supreme Court has issued direction to frame rules for regularization.
Yes.
Rules for regularization has been
They
framed.
have also defined what is irregular appointment.
So you challenge the rules for regularization then. That is not under challenge.
That is in respect to petition number 1 only. Petition number 2 के लिए rules ground नहीं लिया. उन्होंने लिया है कि
No, the selection process was to be conducted by BPSC.
That is with respect to petition number 1, not with respect to
Petition number 2, the competent authority has not issued you the appointment letter. Then there has been no appointment process has been followed.
That is irregular appointment. Appointment
That is
procedure has
illegal
not
appointment.
It is not competitive.
If a person who is not competent to issue you an appointment letter, that is an illegal appointment, not irregular appointment.
Appointment letter is not
ऑफिस
there.
में बैठ के कोई भी आदमी एक अपॉइंटमेंट लेटर दे के किसी को अपॉइंट कर दे, परमिसिबल?
ऐसा नहीं है, लेकिन 85 से अपॉइंटमेंट हुआ है, 85 से लेकर के
So
ये
therefore
85 to 23
you
it has
see,
continuously
unless you are covered by the regularization scheme, you cannot be granted a relief as per the scheme.
That is as per a scheme. The scheme does not say.
You tell us, you show us, you demonstrate that you are covered by the scheme.
Yes.
Show us.
Alright.
Where is the scheme?
The scheme is in the soft copy.
You come prepared tomorrow. We are not going to entertain anything unless you satisfy us that you have a case as per the scheme, because you pleaded before them that you are covered by the scheme.
Scheme, yes. So far as petition number 2 is concerned.
Even for petition number 1.
Petition number 1 clear BPSC का है, that ground is there. But
So,
that will apply
you
for
see,
everyone.
If the appointment is to be made by BPSC or maybe made by UPSC, any appointment letter will be valid. IAS बना देंगे आप? हाँ. How is it possible? बना देंगे तो बताइए आप. You can issue an appointment letter and then declare somebody as IAS.
BPSC से नहीं होगा, staff selection commission से होगा.
कहीं से भी होगा. If there is a selection procedure to be conducted by the staff selection commission or BPSC, Bihar Public
What the Honorable
Service
Supreme Court has said that if it is not regular, if selection process
it is
has
not a case
been,
of irregular selection, it is a case of illegal appointment.
tomorrow I may be coming.
Counsel for the parties are present. Counsel for the petitioner submits that he shall place the scheme of regularization before this court tomorrow for consideration. And he also submits that the case of the petitioner is that of irregular appointment and not illegal appointment. With respect to petitioner number 1, the ground for rejection is that the selection process was to be conducted by the selection commission, right? Selection commission, but that process has not been followed. And so far as petitioner number 2 is concerned, the ground for rejection is that the appointment letter was issued by an authority who was not competent to issue the appointment letter and no selection process was followed.
This is
Scheme
second time litigation.
Third
First time
Third
up to third time.
हाँ दोनों लगाए.
That's
2000 में
There is
2000
no, you see, unless there is a reasoned order, they will keep on litigating. Now there is a reasoned order, we will examine this. You also come prepared. Where is the scheme? You provide a copy of the scheme of regularization, 2015 and 19. You provide it during the course of the day. आज provide कर दीजिए. Scheme है आपके पास? Counter, you are not aware of the scheme of regularization.
Scheme लेकर रहेंगे.
You just provide a copy of that.
As per scheme, your lordship.
You don't have the scheme. You
Claim of the petitioner for regularization is not.
We'll see. Get 2019 also. 2015 and 2000.
Item 30 WPS 6226 of 2023.
This is the second round of litigation. Annexure 10 at page 36 is under challenge. By this impugned order, my claim for compassionate appointment has been rejected, being the wife of the deceased employee.
What is the date of death?
Milos. Date, it's 12th of March 2016.
When did you apply?
Applied in the same year in the month of October. All facts have come in the impugned order.
Just one. I'm just noting.
Milos.
What is the ground for rejection?
Lord's non-registration of my marriage. My name is not mentioned in the service excerpt of the deceased employee. And another more important, Lord's, the rejection is, I am the second wife, the first wife died before my marriage. The death certificate of the first wife was issued 4 years later of the death.
After
date of
applying
death.
of the service loss.
Please.
Sorry.
Yes.
First wife died on 21st of October 2013.
Yes.
My marriage solemnized with the deceased employee on 24th of March 2014.
From where do you get this date?
Lords, I will show the documentary proof, Lords.
And when was the death certificate issued and who has issued the death certificate?
Lords, by the competent authority, Lords, Annexure 2 at case 22. Here, Lords may find the date of death is 21st of October 2013. Date of issuance of this very certificate is 26th of March 2017, and more importantly, Lords, the clause 2, Lords, may kindly have. It says this is to certify that the following information has been taken from the original record of death, which is the register for local area body Panchayat Office 20 of Block Tandwa District Chatra of State of Jharkhand.
Let us see the impugned order.
Milos. May I read it to
Just the relevant paragraph.
the
The first wife.
Milos.
Committee has examined your
Examined
case.
your case and found as hereunder.
Yes.
The late Mahendra Paswan, ex-employee, KDH Project NK area, died in harness on dated 12th of March 2016. That upon his death, you applied for employment on compassionate ground on 3rd of October 2016, claiming to be the second wife of the deceased employee. That the first wife, namely Susila Devi, expired on dated 21st of October 2013, that is prior to the death of the deceased employee. That you have claimed as second wife of the ex-employee on the basis of the documents like marriage card, Aadhaar, etc. But the fact remains that your name as the wife of the deceased employee does not appear in any of the service record of the deceased employee. That further, the deceased employee has neither declared you as the legally married wife, second wife, nor he has given any information to the management about his second marriage, in spite of the fact that the first wife of the deceased employee had died on 21st of October 2013, and he has not informed the management about the death of his first wife, and the death certificate of first wife issued on 26th of March 2017, which is after the
See, the
death of...
death certificate of the first wife has been rejected by citing reasons. It has not been done in compliance of section 33.
Milords. Here, Milords, section 13(3) says it has, when within 1 year of death or birth registration or certificate is not issued, a competent magistrate will inquire into the matter, then it will be issued. Here, my lords, I have shown to my lords, after verification it has been issued by the original records.
Lordship, I have received the instructions and the statement of facts, Lordship. I'll file counter within 2 weeks, Lordship.
No, let me just understand, because ultimately the issue is to be resolved.
Right.
Don't you think that you will require a succession certificate? Because there is a lot of dispute. Not only in connection with the death of the wife, let us assume for a moment that there is a duly issued certificate. What about your marriage?
My lords, Section 7 of the Hindu Marriage Act, my lords, I'm just reading it. Lords. Section 7 says, once Saptapadi is done, marriage is complete.
No, how will they verify your marriage? What is it that you have to substantiate your marriage because you do not have marriage certificate?
Yes.
So therefore, under such circumstances, succession is the only way. Such disputes, can it be resolved in writ jurisdiction? Suppose they will certainly, whatever they have stated in the impugned order, they are going to support that one.
Yes.
Then how will you, the very fact that you are the second wife is required to be established in succession certificate. We cannot decide whether you are the second wife or not once they are disputed. It is not there in the service records. Thus, the employee during his lifetime did not inform about the death of his first wife, nor he informed about the second marriage. Then under such circumstances, anybody can come and claim that a person is a second wife.
Yeah, my lords.
Do you have any children?
No, Lordship.
No issue.
Nothing.
No issue. Earlier, wife.
You see, this kind, there is no problem about it. The point is that we cannot resolve such a dispute in writ jurisdiction. You are wasting your time here.
Lords, I have suggested my client to get a succession.
You get your succession certificate and you consider the succession certificate. Once they have it, you cannot deny.
Here, my lords, may kindly have page 38 for a moment.
There is no point, no. A succession certificate would be required.
This is the Parivarik Suchi. My name is there.
You do.
See her age, Lordship. She's 26 years old girl and she got married in 2014 as she's stating, Lordship. Today on 23rd last year, Lordship, she was 26 years old and she claims that she got married in 2014.
That is at the age of
16 and a half years, Lordship.
You have to get succession.
Lordship, if time may be given, I will.
No counter is required.
Lordship.
Why are you so keen on filing
No,
counter
Lordship, because
affidavit?
they have given me the Lordship. She is also
WPS
provided-
number 6226 of
Lords.
2023.
May I please, Lords, may I keep this matter tomorrow. Lords, I take the instruction from the.
No, you know, I'm not asking you to withdraw.
Lords.
I will simply say that this kind of dispute cannot be resolved in writ jurisdiction. The learned counsel for the parties are present. This writ petition has been filed for the following relief. The petitioner who as per the writ petition is 25 years of age. The writ petition having been filed on 16/10/2023 has claimed that she was the wife of ex-employee, namely late Mahendra Paswan, and who died in harness on 12/3/2016. Her further claim is that she applied for appointment on compassionate ground on 13/10/2016.
It's 310.
On 3/10/2016. It is a case of the petitioner that the first wife, namely Sushila Devi, expired on 21/10/2013. and thereafter the petitioner married the ex-employee. The claim of compassionate appointment of the petitioner has been rejected by the impugned order dated 10/2/2020. Upon perusal of the impugned order, this court finds that the respondents have cited reasons for rejection of the claim of the petitioner on the ground that neither the death of the first wife was reported to CCL nor the factum of second marriage was reported to CCL. And as per the records of CCL, the name of the petitioner does not find place. However, the petitioner has annexed a copy of the death certificate of first wife dated 21/10/2013, issued on 26/3/2017. Even the same has been disbelieved by the impugned order by referring to certain provision. This court finds that there is a serious dispute regarding the claim of the petitioner, and such dispute cannot be resolved under writ jurisdiction. The petitioner has to seek appropriate remedy before the civil court before her claim for compassionate appointment is considered by the respondents. Accordingly, this writ petition is dismissed. However, if the petitioner obtains succession certificate or any other declaration from the civil court with regard to her status, it will be open to the petitioner to approach the competent authority afresh for consideration of compassionate appointment, and the impugned order will not be an impediment for passing fresh order in accordance with. This writ petition is accordingly dismissed. Dismissed.
Item 31, WPS 6.227 of 2023.
Petitioner. What is it?
It's the transfer of the annexure, passing of annexure 20 laws. That is the sixth permission.
What has happened?
In this regard, also I have to file counter affidavit.
What is in the transfer matter? Unless some case is made out, some malafide, some violation of circular.
Nothing has been mentioned.
What is it? Just read it.
In light of the Governor's Secretary letter number 7 Raji dated 7 suppression of the previous notification dated 7 the Vice Chancellor has been pleased to appoint Dr. Meena Singh, the Associate Professor, Department of Political Science of the Graduate College Teacher for Women, Jamshedpur as a Professor in charge of the Graduate College for Women Jamshedpur with immediate effect. She is also directed to operate college bank account jointly with the professor of this college.
And this is a sequel to certain orders passed by the Honorable Governor.
Yes,
21/8. Is it on record? What is her ground?
Also, Lordship, Chancellor has not made party in this matter. That is Honorable Governor.
The matter relates to transfer. Petitioner is absent post tomorrow. Kal discuss kar denge if they don't come. There is no ground.
Yes.
They say that there has been repeated transfers.
Yes.
That is the only ground they have put.
Item 32, WPS 6237 of 2023.
Yes, petitioner.
Notes in this case, the prayer of the petitioner is for payment of entire outstandings arising out of the death of her husband. After adjusting the premium amount for allotment of quarter on long-term lease as per scheme of the corporation. This is the first. And alternatively, the second
When
prayer.
did your husband die?
Husband died on 10/4/16.
2009, 10/6/2009.
2009. 10/6/2009.
As per the scheme, is she entitled?
No, the last scheme which was floated by HEC was of year 2006 and that was for a period of 30 days only. And after that, one scheme already it was floated in 2012, but it was for C and D type of quarters. The petitioner is claiming in 2024 quarter under long-term lease scheme, which is at present there is no such scheme of HEC.
They are of the group.
And also in addition,
Show me the scheme under which you are claiming.
The scheme is improvement.
Which scheme?
Paragraph 25, my lord.
You refer to the scheme straight away. Scheme. Page number 27 is the scheme.
Page number 25. This starts on page 25, my lord.
You are occupying which quarter?
I am occupying the quarter BT.
Quarter number?
BT quarter number.
BT is what?
DT.
D type.
Yes.
D type.
DT by so. Antham 2258. Since 1993.
Maybe. You can't claim adverse possession, isn't it?
No, that is not my.
That is not your claim also.
My claim also, my lord. The one issue involved in the case, my lord, the petitioner, this petitioner is residing in the quarter. This case was, for their case was originally her husband and others were employee of Consumer Cooperative Society, which for HEC employees.
And you just respond to the first query. Since you are seeking a mandamus that you should be given the quarter on a long-term basis, show me which is the circular by which you are covered. And whether it is still existing.
My lord, page 26.
26.
Paragraph 3.3. Cooperative employees and supply labor working in HEC for DT and ST quarters in temporary colony on seniority lottery basis at 5% more than the employee rate as mentioned in column 3 of.
Did you apply for lottery?
My lord.
Okay, what happened?
She had applied for that, but they did not allow because they were of the view that your matter is.
The lottery was held when?
My lord.
When was the lottery held? In the year 2000.
Allotted?
When was the lottery held?
This continued up to the 3004 to 2005, my lord. This scheme was continuing with certain changes. After that, what they did, my lord, whoever cooperative employed, the award was in favor, and they had gone in Reed Court and LPA, Supreme Court. They told your case will be considered only after finalization of the.
Where is it? You are telling us a story. Where is that story in the writ petition?
I think yes, my lord. It is there. Page number 12, my lord. Paragraph 11.
You are wife of N.K. Pandey?
No, my lord.
Then?
Raghu Singh, one Raghu Singh. The matter was referred for 44 employees.
Okay. All right.
44 employees.
You were there? You were also there?
My lord.
You filed your contract. Learned counsel for the parties are present. District counsel for the respondents is directed to seek instructions and file a counter affidavit in the present case by 5th March. Will be joined by 12th, post on 13th under the heading for admission. If there is any admissible retirement dues you pay,
Leadership, all the, in that.
is there usual? You can also bring if there is an eviction order. There could be, we do not know.
That I will take instructions with that regards. But so far as the scheme is,
that does not exist.
That we do not have a scheme at present. Further in 2000, I do not remember the exact year leadership, but Union of India had come up with a notification that all PSUs cannot lease the immovable property without permission of the government.
So you bring that also?
Yes.
There is a legal bar.
Yes.
My lord, very recently, very recently, Lord Chief also had passed the order to companion. My lord has ordered within 30 days from passing of this order, the company will deposit the amount, and if at all the quarters are not to be allotted, the employee concerned or dependent will surrender the quarter after 90 days, and they will get the benefit. The alternative.
So you are ready to vacate the quarter?
I am ready to vacate the cover if at all it is not agreed. I have given.
If at all means what? You can't have like this. You give an undertaking that you vacate, your all admissible dues will be paid.
I have already given, my lord.
So you vacate? You give an undertaking that you vacate, you will vacate in 3 weeks, 4 weeks, whatever.
This is not the DB order, my lord.
We are not concerned. We will see that. We will see the counter affidavit and pass it.
My lord.
There is no adjudication as such. It is just an order.
Right? This writ petition has been filed for allotment of quarter.
You file your affidavit.
Item 33, WPS 6476 of 2023.
Yes, petitioner.
Notes matter relates to appointment in the post of the graduate assistant teachers notes, and the petitioners participated in the notes JTET examination in the year 2016, and thereafter my lords no examination has been conducted. If my lord will kindly see.
Okay, no exam conducted. So
and during this period, my lord, they have crossed the upper age limit notes, and therefore they have approached this court notes. For a moment, kindly see page number 96, the certificate of the JTET, wherein we wrote in the note at the bottom.
yes.
97 at the bottom.
It is valid for a period of 5 years.
5 years because. But during these 5 years because, no such examination has been conducted because, and this petitioner has crossed the upper age limit in view of the present advertisement because. So the only prayer of this petitioner because is shifting of the cutoff because, which has already been done in another examinations by this honorable court because in divisionment, and fortunately my lord was part of that bill.
I don't remember, you see. It is very difficult
I have
to
the
remember.
orders, my lords, in judicial service examination.
My lord, while sitting while sitting in with Honorable Acting Chief Justice,
Must be, but I don't remember the orders.
That you are altogether different matter, Your Lordship. Mazhar Malik Sultan case, Your Lordship, judicial office.
It is a different order altogether. This is a different order altogether. This is a different order.
And my lord, in this case,
this is induction of judicial officers. And there was a clear direction by the Honorable Supreme Court that every year it has to be conducted.
But here in the instant case also, such examination has not been conducted.
Merely because, you see, you don't have a right. Merely because the respondents do not conduct examination, and in the meantime you cross the upper age,
Vacancy
then vacancy must be there. They don't want to induct. Is there any, can any mandamus be issued for them to?
But opportunity may be given with a sympathetical case, their cases may be considered.
Sympathy beyond law, we cannot extend. We do not extend sympathies beyond law. You show me your right, I will give you a relief. Full relief without any sympathy. There is no such law.
By virtue of annexure 4 they have approved the respondent authority to consider the case.
Then you withdraw and do whatever. I will not issue a mandamus to consider. You are well versed with law. We know that. If you want to pursue your remedies, you may pursue, because it would be essentially a matter of policy. Right? We cannot ask them to change their terms and conditions of advertisement, etc.
The only ground with this petitioner's notes, since the examinations after 2016 for appointment of the trained graduate teachers.
You have already crossed the age, no?
And the certificate.
You have already crossed the age. Even if you had the certificate, you have already crossed the age.
That has compelled us to knock the door of this temple of justice.
Not this. I think if you want to pursue your remedies, you pursue your remedies before the authorities or the political heads or whatever. But no mandamus can be issued in this manner.
My representation is pending there, so they may.
You pursue your representation, you withdraw the representation. That much of observation
has not yet been conducted, and
so therefore, all the more reasons to pursue your representation.
And in view of the order of this honorable court in another cases, the date has been extended, and that is up to that has expired.
Where is your representation?
That is at page 127 and lecture 4.
So you pursue your representation, but don't press this. We can't issue any mandamus. Will you pursue your representation?
Yes, my lords. In view of representation, they may.
The learned counsel for the parties are present. This petition has been filed for the following relief. The counsel for the petitioner has submitted that an advertisement has been issued for recruitment, but the examination of Jharkhand, the examination of teacher eligibility test was held way back in the year 2016, and thereafter no further examination was held, and now the petitioners have become overage. He also submits that the petitioner has already represented before the respondent number.
Respondent number 5 in addition.
Respondent number 5.
The Secretary of Jharkhand Staff Selection Commission.
Respondent, he has represented before respondent number? Respondent number 2. The learned counsel for the respondents has submitted that so far as the terms and conditions of selection process is concerned, the same is essentially a matter of policy. So, no mandamus be issued. The petitioners do not have any right to ask the respondents to conduct examination for the purposes of selection from time to time. यही है आपका. Considering the aforesaid submissions and the nature of the relief which has been sought for in this petition, this court is not inclined to issue any mandamus. As prayed for. However, this order will not be not come in the way of the petitioners to pursue their representation which is already pending. That's it. This petition is accordingly disposed of.
Item 34, WPS 6523 of 2023.
Yes, petition.
Lord, I will be issued this the petitioner pays for direction of the respondent to regularize the service of the petitioner, especially in view of the fact that the petitioner is continuously working as bench clerk in the electricity ombudsman since last 17 years.
Is there any sanction post?
Yes, ma'am. The petitioner is appointed on sanction post, and even the state government has also recommended for appointment of all the persons who are working in the Jharkhand State Electricity Regulatory Commission and in subordination thereof.
Where is that recommendation of the state government?
The other I have stated in para 60 of my application, my lord, I have given the statement. The documents I have not annexed, but in other petition, my lord, I have also annexed the documents. Wherein the state government has also recommended to regularize all these persons.
Where is that document?
In another petition, my lord, it's one batch
That
matter.
that's been disposed of.
No, that matter is pending, my lord.
Case number?
Case number.
Let me just place that matter. All the tag matters have been placed on 28th of February.
28th.
28th of February.
The learned counsel for the parties are present. The counsel for the respondents has submitted that similar matters are posted on 28th of February 2024. Before this bench? Before this bench. One case number?
WPS number 6451 of 2023.
WPS number 6451 of
2023.
2023.
This case was rather taken up on 7th February 2023.
And the corrected case is WPS number 6451 of 2023. Considering the submissions, let this matter be tagged with WPS number 6451 of 2023 and be posted on
28th February.
28th of 28th of February 2024 along with analogous cases.
In all other cases, counter affidavit has been filed. This
In
case
the meantime, the respondents shall file the counter affidavit in the present case. Are you there in all the cases?
Yes, my lord, I am.
What is the nature of counter?
Lord, we are opposing, my lord, because at the time of their recruitment, my lord, there was no sanction post, no advertisement, no reservation was followed. They were just engaged, my lord. By the passage of time, my lord, they have continued. And now, my lord,
When was the post sanctioned?
Lord, that was sanctioned much way back, my lord. They are
So
working since 2000.
you should bring on record the day on which it was sanctioned.
Lordship, we have.
And since they have been working for so long, you should also think of giving them some relaxation.
We have given, my lord, rather, my lord, an advertisement has been floated for permanent regularization, giving relaxation and waiver
To all these petitioners.
All the petitioners.
They don't want to participate.
My lord, few of them have participated and few of them have not, my lord. There is even the
That
advertisement.
also, that details you should give in your comment.
I'll bring it on.
All these things have been considered in the batch matter, which is the lead case. In that case, my lord,
Which is the lead case?
the lead case is 3544 of 2023.
3544
of 2023, wherein there are altogether 6 matters, and in all these matters, my lord, this honorable court has given interim protection to the petitioners, and they shall not be removed.
We will decide it. 28 तारीख ज़्यादा दूर नहीं.
और उसमें that matter is subject to the LPA. There is one.
We'll see that.
All these matters will be taken up to 28.
Which is that connected LP?
That connected LPA is 282 of 2023.
282 of
2023.
The learned counsel has submitted that amongst the lead case, the lead case in the batch is WPS number 3544 of 2023, and and one LPA dealing with the same issue is pending before the division bench, being LPA number 282 of 23.
That means the LPA has been preferred by the state. Writ petition was decided in favor of the petitioners.
LPA has been preferred by the state and the writ petition preferred by the writ petitioners was allowed.
In that
LPA जरा निकालिएगा, writ का order भी निकालिएगा, LPA number 282 of 23 along with the copy of the writ. Writ का order भी है?
हाँ.
3544 3546 है
3546 होगा, 3544 नहीं होगा. 3546 writ petition का नाम है.
Main case वो order दिए होगा.
इसमें 3546 है, लेकिन बैच में जो लीड केस है वो 3544 है. रिकॉर्ड उसी का पढ़ना है. This is computer operator. It is not relating to this particular recruitment
In
process.
that matter, my lord, it was a batch matter. It was also a batch matter. The
We'll
LPA
see.
is batch matter.
We'll see.
defect. Orders with defect attempt 2 WPS 303 of 2023.
Your Lordship, there's a humble prayer with respect to serial number 36. Your Lordship, the
It
matter.
will be taken up, don't worry. You were also granted time earlier, 3 weeks to remove the defects. It is not your leisure that whenever you will feel like you will remove the defects. It was passed on 5th of January 2024. Time till 5th of March 2024 is granted to the petitioner to remove the surviving defects, the entry. If the defects are removed within the stipulated time, pose this case on 12th of March under appropriate heading 24. All the cases same order.
Serial number 17, there is an objection, my lords, kindly have perusal of serial number 17, my lords. The registry had made an objection with regard to the maintainability of the writ petition itself, my lord. And this writ petition ought to have been listed in division bench since the order of the tribunal, central cat's order is there, my lord, which is under challenge.
Okay. Serial number?
Serial number 17.
So it has to go to the division bench?
Yes, my lords.
Serial number 17.
Yes.
The
It
learned
is,
counsel for the petition has submitted that impugned order has been passed by Central Administrative Tribunal. Therefore, this matter may be listed before division bench. As per roster. Office is directed to place this case before appropriate bench as per roster after taking due permission from the Honorable Chief Justice.
One matter that is serial number 38.
38 is defective.
No, it is
It
not.
will be taken up just now. Please
It
hold
is
on.
not defective matter.
Please hold on. It will be. अभी 1:05 हुआ है. 25 minutes of court time is still there. Just hold on.
Item 35.
Serial number 10, Your Lordship. It was under the headings orders with defect. 2 defects are remaining, Your Lordship. With respect to 1 defect, we have filed a supplementary affidavit, Your Lordship.
So they will take care.
Your Lordship, it is written that the Honorable Court has to verify.
Just serial number 10.
10, Your Lordship. 1 defect is that annexure 9 appears to be the type copy. It may be verified or true copy may be given. We have filed a supplementary on 6th of October 2023, Your Lordship.
Annexing that?
Your Lordship, we have verified annexure 9. It is the copy of representation which was retained by the petitioner with himself, and that copy we have annexed with the writ petition. We have given the statement.
Annexure number? Annexure?
Annexure number 9, Your Lordship. Page number 39 of the writ petition.
It does not contain your signature. That
Your
is why.
Lordship, this is the copy of the representation that petitioner.
This is defect number?
Defect number 4, Your Lordship.
Defect number 4. What about other defect?
We have to give type copies of fresh type copies of 2 pages, Your Lordship. That will
Counsel
give.
for the petitioner submits that. So far as defect number 4 is concerned, the same may be ignored as the petitioner has annexed the copy of the representation which was retained by the petitioner after filing the same before the Honorable Governor. Considering the aforesaid submission, she submits that a supplementary affidavit has also been filed to that effect. Considering the aforesaid submission, the defect with regard to defect number 4 is ignored for the time being, subject to any objection which may be raised by the respondents.
Yes. And with regard to type copies, Your Lordship will file it within this week.
So far as the other defects are concerned, let the same be removed with same time frame. By 5th of March, preemptory. It will come on 12th of March if you remove the defects.
The matter number 3, there's only a defense regarding an advocate welfare stamp. It will be filed during the court.
You remove the defects. I've already passed an order, you remove the defects as per the order. Yes.
Item 35, WPS 6579 of 2023.
Yes,
एक
petitioner.
डिफेक्ट था मैम, योर ऑनर.
Serial number?
Serial number 8.
8. What is the defect? And what do you want?
2 and 5. Defect number 2 and 5. और 2 मेरे पास टाइप कॉपी देना था. सो ये इसके लिए बस 2 weeks का टाइम दे
आपको
दिया.
टाइम दे दिए 5 तारीख तक. 5th of March तक का टाइम दिए हैं टू रिमूव द डिफेक्ट्स. नहीं रिमूव करेंगे तो केस ऑटोमेटिकली डिस्कस हो जाएगा. ठीक है. You are regular practitioner here. You have come from outside. From where have you come? Chaibasa. So you have any local advocate who is helping you
Yes.
in the matter of filing?
Yes.
You are there. So इनको जरा फाइल दिखा दीजिए. आप फाइल देख लीजिए, है ना. कोई डिफेक्टिव रह जाएगा तो डिसमिस हो जाएगा. So you ensure that it is properly done. Okay. कुछ रिमूव करना है तो अभी कर लीजिए, बाकी फाइल करिए.
Item 35.
In this case, petitioner is class 4 employee, working as PU at Dalton. He was transferred to headquarters Ranchi, and thereafter he was again transferred to the office of respondent number 2 at his residence.
So
there he has filed one representation.
no. What transfer order? If you want to pursue your representation, you pursue your representation. We will not issue any mandamus.
My submission is his class 4 employee inter-district transfer is not permissible. But that circular is not with me.
So the anchor sheet of your argument is not there.
Furthermore, what happened, he was...
Have you joined or you have not joined?
I have joined. I was working.
Furthermore,
but,
what?
I was sent to the residence of respondent number 2.
So?
To work
So you will choose where you will work?
No, but my work is in office, not in the residence.
No, we can't do it. There are official works in the residence also. All the officers are working 24 hours. They work at residence also.
Yes. So, but my lord, when he joined, he fell ill. He took leave. His leave was not granted.
So that is a separate thing altogether.
Therefore, he is not now allowed to rejoin the post.
So we can't ask that also.
And his salary is also not being paid right from January 2023.
There must be some show cause must have been issued to you.
No, nothing.
उनको क्या देख रहे हैं आप बताएंगे?
नहीं, हमारे पास अभी तक कोई शोकॉज नहीं आया है।
ये जब कहानी सुना रहे हैं सब रीट में है कि ऐसे सुना रहे हैं?
नहीं, टोटल सुन।
कहाँ बताइए? Where is it?
Entire he was appointed in the year 1989, joined in the year 89, working at the Tengan under the respondent. Worked there for last 33 years, and now on the verge of retirement he has been transferred to.
When are you scheduled to retire?
His he is now, is it about
2030. 2030.
2030 तो बहुत time है. About to retire तो you cannot say.
he has given all the medical prescription to show that he was lying in, and he was not allowed to leave.
You are making so many allegations, but nobody has been made party by name. Then, how do we adjudicate such kind of an allegation? The allegations are such that we could have filed an FIR also. We do not know. The person is not being named party by name. You are telling that he's misbehaving, abusing.
That he has written in his
Yes, but
representation.
nobody is there party by name. Then how this writ petition can be entertained and any relief can be granted to you?
Let me allow to make amendments to the petition.
No, not amendment. We will not permit amendments like this.
Or my lord may observe to consider my this representation sympathetic.
No. That also we cannot say.
I am ready to withdraw the every application.
You pursue your representation.
Yes.
You have filed representation before whom?
It has been file number 3, respondent number 3. Yes.
After some argument, the learned counsel for the petitioner seeks permission to withdraw this writ petition and submits that he shall pursue his representation which has been filed before respondent number 3 for redressal of his grievances. Any objection?
No, madam.
Counsel for the respondents has no serious objection to the prayer made. Prayer no support कर दीजिए. Considering the submissions, this writ petition is dismissed as withdrawn. The petitioner may pursue his remedy as may be permissible under law.
And it shall be considered sympathetic. At least some time may be allowed so that it may be useful.
Nothing we will not say.
Item 36, WPS 6590 of 2023.
जो है उनको बोल दीजिए.
Petitioner.
Ladyship, the present matter pertains to the seniority cum merit list, which has a number of irregularities. Your Ladyship, there's a humble prayer here. A similar matter of Sanjeev Deo versus the state, which is WPS 6619 of 23. this was listed on the 6th of February 24, wherein this Honorable Court has been pleased to direct the respondents to file a counter by 27th of February, and the matter has been listed for 6th of March.
Counter, are you there in that case?
No. The matter, the two matters pertains to the same seniority cum meritless, Your Worship.
You have private respondents?
No.
If you are aggrieved by the seniority list, will you not impede the persons who are affected by your prayer? Then how any relief can be granted to a petitioner with regard to his seniority unless the persons who are going to be affected are included as party?
Your Ladyship, presently in this particular writ, there was a preliminary list that was issued, and based on that, this particular writ petition has been filed.
So you raised your objection with the...
Yes, Your Ladyship. The representation has also been filed in the present
in connection with the seniority list.
Yes, Your Ladyship.
So that has not been considered.
No, Your Ladyship.
Final seniority list has not been published.
It has been published after filing of this writ petition.
Still you are aggrieved?
Yes, Your Ladyship.
That is not on record.
Your Ladyship, that will be brought on record because we have been given an opportunity to file a rejoinder after the counter has been filed in the other matter. Therefore, it is a humble prayer that the two matters be tied up and all the prayers and all the further submission.
WPS number 6590 of 2023. Counsel for the parties are present. The petitioner submits that arising out of the same seniority list involved in the present case, tentative seniority list
Yes,
involved in the present case, another writ petition being WPS number 6619 of 2023 has been filed, in which counter affidavit has already been filed.
No, Your Ladyship.
Okay. And the said matter is posted on 6th of March.
Yes,
Counsel for the petitioner has also submitted that during the pendency of this case, the final seniority list has already been published, but the same has not been brought on record. Counsel for the respondents is directed to seek instructions and file a counter affidavit in the present case by 3rd March, post on 6th March with WPS number 6619 of 23 under appropriate. वो जिस सदन में है उसी है.
Item 37.
Yes, madam. Respondent, if the final seniority list has been published, you should bring that on record. You must have considered their representation. That consideration should also be brought on record. Yes.
Item 37, WPS 7293 of 2023.
Ladyship, in this I am seeking for passover. My senior will assist your ladyship. He is on rights before DB2.
Earlier also, I think you had paid for passover.
No, ladyship. In earlier occasion, there was a direction to bring on judgment. However, my senior will assist and he is on legs before DB2. This is the matter where 2 days before I was dismissed before my retirement.
Counter affidavit has come.
No,
Counter is required, madam. Counter has not been. I will file counter within 2 weeks.
I have not called for a counter.
Yes, and on the previous
इसमें सुप्रीम कोर्ट का है जो केरला हाई कोर्ट ने ऑर्डर दिया था कि ग्रेच्युटी का इंटाइटल है उसको स्टेट सेट करें. सिविल अपील नंबर
You can give the citation. For that you don't need a counter, isn't it? Civil appeal number.
सिविल अपील नंबर 7440/2021 एंड एक और है 7441/2021. ये ऑर्डर डेट है 15/3/2022 का.
Counsel for the petitioner seeks adjournment. Tomorrow he will be there.
Ladyship, he is today there. He is on legs on DB2. That's why I
कितना
was.
केस बाकी है?
Ladyship, I am praying let it come after a day because we will analyze this judgment. We are also relying on judgments, Ladyship. So one.
So you are seeking adjournment. You tell us that you are seeking adjournment.
Since they are relying on one judgment, we will analyze that
Counsel
judgment.
for the parties are present. Counsel for the respondents has submitted that though there is no order for filing a counter affidavit, but the respondents would be relying upon a judgment passed by the Honorable Supreme Court in Civil Appeal number 7440 of 2021 with 7441 of 2021 decided on 15/3/2022. Copy है आपके पास? निकाल लीजिएगा इसका copy. Submission. You just take a print. You have noted down?
Little bit I have noted down.
Counsel for the petitioner submits that.
I was
We do
going
not.
through this judgment.
Counsel for the petitioner seeks adjournment to examine the judgment. When do you want?
PTJ में आपके day after.
Post on Monday. Under the same heading. Next.
Item 38, LPS 7618 of 2023.
Yes, petitioner.
Just due to some inadvertence, the accusation of the petitioner in the main petition as well as in the affidavit has wrongly been mentioned and type that of Defect in place of his name. And I such matters, I may be permitted to withdraw this application so that I can file a fresh application.
No, I don't get it. This address has been wrongly mentioned.
It is. It has been mentioned of Defect matters, though
Instead of
Sahibganj.
Sahib.
I am from Sahibganj district, but due to some mistake, it has wrongly been mentioned.
Learned counsel for the petitioner seeks permission to withdraw this petition by submitting that the address of the petitioner in the present case has been wrongly mentioned. Petitioner is from Sahibganj and the address has been shown from Devghar. He submits that the liberty be reserved with the petitioner to file a fresh one. Any objection?
No.
The learned counsel for the respondents has no objection to the prayer for withdrawal. Prayer quote कर दीजिए. This petition is permitted to be withdrawn. The petitioner may file liberty is reserved with the petitioner to file a fresh petition.
Sign कर लीजिएगा sir. Item 39, WPS 7619 of 2023.
In addition, this case pertains to arrears cum family pension. Whereas petitioner's late husband was appointed on 20th June 1977 as Adesh.
20.
Yes, brothers.
206-90
77
as
Adesh Pal in Nagar Parishad Pakur, and he died on 16th of December 2011. Mallards, he has served 34 years plus services, and in this case the prayer is of number one, firstly 30% of 21 months of salary arrears as per the 6th pay commission, and secondly the grant of first, second and third ACP benefits along with the interest, and thirdly the family pension after revision of pension on the basis of 7th pay commission, and fourthly the
who is for the respondents? Have you filed any representation?
yes, brothers. Section 5 series page number 20 of the writ petition.
Yes, Lordship, see, relevant parties respond number 3. Pakur Nagar Parishad.
Who is representing Pakur Nagar Parishad?
As far as pension is concerned, as I know, Lordship, that is not applicable in the case of Nagar Parishad.
Whatever is payable, they will be subject to verification of the records, because these old matters very difficult to find the records regarding arrears of salary. But if he has been an ex-employee, then pension or whatever be the benefit, 6th pay revision or whatever they are. This is not a pensionable post. No pension. Any idea?
Yes, not as I know, Lordship, the corporation, municipal corporation and Nagar Parishad has no
scheme of pension.
Scheme of pension. There is some corporation has the scope of
Okay.
pension, but they raise by themselves also.
Counsel for the, you have served on this Nagar Parishad? They are not there.
Yes, yes, brothers.
It can be disposed of what's there in this case. Counsel for the petitioner and respondent number 1 and 2 are present. This writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the husband of the petitioner was appointed on 26/1977 and was working as Adesh Pal under the respondent number 3, who expired on
16 December
16/12/2011 while in service.
Yes, ma'am. While in service.
While in service, he submits that the petitioner is the widow of the ex-employee of respondent number 3. She has filed a representation before the respondent number 3 for the purposes of service benefits of her late husband, including including pay scale of 6th pay commission, and he has also submitted that the last pay drawn by the ex-employee is to be calculated accordingly, and the petitioner would also be entitled for pension. The learned counsel for the state has submitted that, to the best of his knowledge, the employees under the municipal commission.
Parishad Council, Municipal Council, another Parishad.
Okay, municipal council are not entitled for pension, but he submits that the same would essentially depend upon the scheme that may be applicable to the concerned municipal council. After hearing the learned counsel for the parties, for the petitioner and the respondent number 1 and 2, and considering the nature of relief prayed for by the petitioner, this court is of the view that this writ petition can be disposed of, enabling the petitioner to approach the respondent number 3 for redressal of her grievances, which can be examined on the basis of the available records and applicable rules, regulations and guidelines so far as her late husband and the petitioner is concerned. This writ petition is disposed of with the liberty to the petitioner to approach respondent number 3 by filing a detailed representation mentioning about each and every claim in separate paragraphs, with supporting document which may be available with the petitioner, along with a copy of the writ records within a period of 15 days. Can you put 15
1
days?
week.
1 week?
I'm sorry,
1 month. Within a period of 4 weeks from today. Upon filing of such representation, the respondent number 3 is directed to consider the grievance of the petitioner and pass a reasoned order after verifying the records and granting an opportunity of hearing to the petitioner or her authorized representative. The reasoned order will pass within a period of 4 weeks from the date of representation and be communicated to the petitioner through speed post. If the petitioner is found entitled to any monetary benefit out of the reasoned order, appropriate steps be taken by the respondent number 3 so that the amount be remitted to the petitioner directly in her bank account, whose detail be also provided by the petitioner in her representation. The needful be done after verifying the identity of the petitioner, inasmuch as the late husband of the petitioner is said to have expired way back as on 16/12/2011. This writ petition is accordingly disposed of.
Item 40 WPS 7645 of 2023.
Yes, petitioner. This is 21 of 2016. We have dismissed the writ petition today itself. We have dismissed one writ petition today itself. Same order. There is a direction of the Supreme Court also that no order is to be passed by the High Court.
लेकिन एक ऑर्डर सुप्रीम कोर्ट का इसी में आ गया है, इसी डॉक्यूमेंट वेरिफिकेशन में डायरेक्टली दैट पर्सन मूव्ड फॉर द पर्सन कहा कि नहीं किसी कारण से अगर नहीं मिला है तो आप इसको दीजिए,
तो आपको भी सुप्रीम कोर्ट जाना पड़ेगा, ऑर्डर हम लोग कर देंगे अकॉर्डिंगली. सेम ऑर्डर वो 21 of 2016 का एडवर्टाइजमेंट का. They have relied upon certain orders also passed by 200 benches. Give me the list. You have given the list.
All the 5 cases.
All the 5 cases का list है इसमें. No, you just take care. आपको बता रहे सुप्रीम कोर्ट का डायरेक्शन है स्ट्रेट अवे कि कोई ऑर्डर नहीं हाई कोर्ट पास करेगा. Very difficult to pass an order. Next, continue. Dismiss it.
Item 41 WPS 7655 of 2023.
Yes, petitioner.
In this case, my lord, petitioner had applied for the selection of intermediate and teacher, and in the counselling, my lord, respondent denied to take counselling of the petitioner because he is para teacher, and he has applied in a category of non-para teacher, my lord. And
where have you stated that you being para teacher you applied under non-para category?
My lord.
Where have you stated that you applied under non-para category?
My lord. Yeah. Para 10, my lord.
Para 10.
Page 11.
Page 11.
Post of intermediate trained assistant teacher 2015 to the Honorable Court has directed to the concerned Honorable Court additional counselling for non-para teacher.
No, where have you stated that you had applied for
My
it?
lord.
You were ever called for counselling or never called for counselling? Were you ever called for counselling or you were never called for counselling?
Not never called my lord, because he is a para teacher. For
Where
that,
have you stated?
my lord.
Your Ladyship, may I mention something? Your Ladyship, the petitioner had filed a writ earlier and it was dismissed for the same prayer.
For the same prayer?
Yes, Your Ladyship, and he had further filed an LPA which was dismissed as withdrawn.
But that was the another issue, my lord. Because of that,
Same prayer,
I
same
mentioned my lord, para 11. I have mentioned, my lord, about that. I have mentioned in para 11, my lord.
WPS number 3215 of 2016.
Yes, I have mentioned, my lord, in para 2 also, and I have
LPA number 498 of 2018.
498 of
2018.
due to lack of the information not appear in the counselling, my lord. That point was considered, and thereafter several judgment of this honorable court, my lord, in batch cases, in Extra 1 and 1 by 1, my
we
lord,
have also
decided.
passed an order saying that if a person has been called for counselling and he has not participated, he will not be entitled for counselling. That judgment is also there.
But I have annexed the judgment, my lord. In Extra 1 is there, my lord. Being a para teacher, my lord, I have applied in non-para teacher, in category. I have stated, my lord, due to lack of information and message, I have not appeared in counselling. That issue was decided, my lord, earlier.
Your Ladyship, may kindly come to page 141 of the writ petition. the relevant para for the LPA that he is relying on. And it is limited only to the present writ petitioners.
No, there are numerous other judgments also passed, but the point is that he was already called for counselling once. You see, there were batch of writ petitions. One or the other person was moving this court. Ultimately, there is one batch. There is another batch which we have disposed of with the Honorable Chief Justice present. Right? So, in cases of para teachers, we have passed an order that if they are entitled as per that, because we have passed specific order that we have, if a person has already been called for counselling, we are not going to permit him second time, even if he participates or he does not participate. So his candidature will not be considered as per that. But whatever it is, let me just get hold of this. You were called for counselling, no? But you could not participate.
Not participated and not appeared, madam. Not appeared.
WPS number 7655 of 23. Post this case with the records of WPS number 3215 of 2016, disposed of on 30/4/2018, and LPA number 498 of 2018. No, it was simply withdrawn. CPA WPS number 3215 of 2016. Tomorrow. There is one more judgment which that we have passed. That persons who have already undertaken counselling, they will not be. They will call for counselling, they will not be entitled. इसको कल record के साथ देखेंगे. Let us have a look what relief have been paid. Okay, call.
Item 42 WPS 7659 of 2023.
The reasoned order pursuant to the direction of the Honorable Court is under challenge. It was a specific case of the petitioners in the previous round of litigation that juniors have been promoted. The Honorable Court directed that I will file a representation and they will consider keeping in mind that the juniors have been promoted or not.
Case of juniors have been considered?
Juniors have been promoted?
No, case of juniors have been considered
No,
while disposing of your
no.
representation?
No.
Where is your representation giving the names of the juniors who have been promoted? Who are the juniors who have been promoted?
Well, I have indicated in the pleading portion also.
No, not pleading. I
Yes.
just want to know in your representation.
Yes. Annexures 7 series. Well, let me kindly come to page 79.
Yes, 79.
Second paragraph. I fall in the category of scheduled tribe, but the list does not contain my name. Rather, it contains the names of junior engineers who are lower position in the seniority gradation list, whose position in the seniority list are 1289, 1292, 1297, 1299, 1300. My name in the seniority list figures at 1150.
Well, Learned Counsel for the petitioner submits that the impugn order has been passed pursuant to the earlier order passed by this court, but the specific plea taken in the representation that the petitioner, who is a scheduled tribe candidate, his promotion has not been considered, although persons junior to him have been considered. He submits that it was specifically mentioned that position in the seniority list of such junior engineers are 1289, 1292, 1297, 1299 and 1300, and that of the petitioner was 1150.
There are 6 petitioners and all 6 representations are there indicating
all
this
are
data.
scheduled tribe?
Yes, ma'am. All are scheduled.
Similar representation?
Similar representation indicating this
The
data.
Learned Counsel submits that all the petitioners are belonging to scheduled tribe and similar representation with the same grievance has been raised in the various which have been annexed along with the writ petition. The counsel for the state is directed to seek instructions and file a counter affidavit of respondent number 1. Who has passed the order?
Yes, my lord, the secretary concerned of the firm.
Principal Secretary, Road
Yes,
Construction Department.
Yes, my lord.
By the respondent number 2. Right?
My lord.
You inform the counsel for the others.
Yes,
Let the counter affidavit be filed by 5th March, rejoinder by 12th, post on 19th March under the heading for admission.